I'm seeking your lordship's kind leave to file a matter. Urgency is this: the subdivisional officer passed the order for demolition of encroachment. My land is the Noyanjuli. Whether Noyanjuli coming within the purview of the PWD land,
Yes, it's a
that
state
should
land. Noyanjuli cannot be a private land.
on the Jilla Parishad's office, not PWD.
Whatever is the office,
So,
it is a state land. Whether it is Jilla Parishad or whatever, nothing doing.
Lordship,
File
kindly
it in the
decide the matter.
department. File it in the department.
All right. Grateful.
Release by?
The notification which I am carrying the writ petition is actually pertaining to land.
All right. So it is not in this determination. Which item?
Monthly is 1100. I've written it in the slip, your lordship.
1100 release for want of determination.
May it come in under the urgent motion?
You file it, then mention.
All right.
Slip is not required, and you are for the petitioner? All right.
My lord,
All right.
my lord has been pleased to grant leave to a matter on Tuesday, my lord.
Yes.
That matter will appear on Monday. Now, my lord, a similar matter has come
What is the
my
matter?
lord, with regard to election and counter-election in the union of the postal department, my lord.
All right.
And this is a similar matter, my lord. It has been listed today as item number 189. My prayer is that 189, my lord.
189?
Yes, my lord. So,
All right.
my lord, both these matters, my lord, may be heard analogously, my lord. The leave matter is different, my lord. It is supposed to come on Monday. A similar matter has been listed today as item number 189.
Let the matter appear in the list on Monday, and this can be tagged.
My lord.
189 টা দিয়ে দেবেন তো। What is the other number?
My lord, I have mentioned the number here.
নাম্বারটা দুটো একসাথে দিয়ে দেবেন তো।
Lordship, may I be permitted to mention for one contempt?
Notice should be served.
Yes.
Lordship, may I be permitted to mention for one contempt application?
For?
Or there is an order of
For what? Enlistment?
inclusion in the list.
No, inclusion is over.
May I have your lord?
Lordship, it's the urgency that the order.
Inclusion is over. I have accepted all slips for inclusion. Not a single one has been
Lordship,
refused.
This is the Lordship, the order. Lordship,
No,
was
don't
the
make
first
faces.
made for. Lordship, then when I come.
Update the list. Well, my lord, this is a contempt application. My lord, the petition is not getting pension for the last 2 years.
Yes, come in afternoon session. And if you know who is the other side, please bring him.
May I have your lord?
Should I
All right.
come?
May I have your lord?
Should I inform it?
Yes, please inform and bring him also,
Lordship,
so that it can be taken up.
Lordship, then should I come next week?
Yes.
May I have a lordship? This is for extension of interim order, my lord.
When is it expiring?
14th of July, my lord. On
Give.
Monday. I'm grateful.
May I have your
Serve notice.
Yes, your lordship.
May I have your lordship's kind leave to mention my lord?
1 minute.
Yes, my lord, with F number, my lord, I have not.
F?
Yes, not filing number.
Yes.
Without the, my lord, the writ petition numbers will coming today.
Yes.
The urgency is that, my lord, my lands which are Bastu lands are being sent to the waterways department, my lord, wetland department, quoting an order of the National Green Tribunal which doesn't direct anything of that. It is being disclosed as if it is a lowland. And they will issue an order notification saying that this land is included in the wetlands and well, I'll be losing my right. No hearing, no nothing. No notice.
So why are you not there before the tribunal who passed the order? Why are you
There is
here?
no order. That is the point. Your lordships on the previous occasion in respect of this original application was pleased to interfere in matters where your lordship may remember that the DM had quoted an order of National Green Tribunal saying that there is a direction of the National Green Tribunal, but in fact, when the order is being seen, there is no direction to that effect. But quoting that, my land was not being directed to be converted. That was before conversion. In this case, my lord, I'll show I have already converted. It is a Bastu land, but while forwarding, it is being shown as Nama, so that, my lord, if the waterways passes an order and declares this to be a water body.
What is the urgency? Nobody has passed any order. No steps have been taken. You are apprehending that steps may be taken.
It is only for approval. The point is that I should get an opportunity to defend and show to the DM that, look, there is an order of conversion. Without that, my lord, it has been sent. And it's the Bastu land has been sent. Now, what will happen? Suddenly, there will be a notification and, my lord, I'll be losing my right. I'll be praying that before this entire process, first the process is totally without jurisdiction. If the process has to be initiated, then I should be given an opportunity in the process. There is a direction of the Supreme Court which says no direction is with regard to National Green Tribunal. This is not with regard to the proceedings.
Next, Wednesday it will appear. 16th, serve notice.
My lord.
Serve notice.
The F numbers are there, my lord. WPA numbers will be coming in course of the day. I
Then give the WPA number, regular number.
then, my lord,
My lord, item No.14 of contempt application. There is some urgency, my lord.
Is it an application?
Contempt application?
Application. Are you aware who your other side is?
No, we know the corporation, but private response is difficult to serve. So let it be on next Thursday, top of the matter, because they are violating and they are
Who is violating? The private respondent.
with the help of corporation is helping.
Bring the corporation advocate, I'll see.
Today,
Today, bring the corporation advocate.
My lord,
Fine.
under compelling
Fine.
circumstances, my lord, I am mentioning, my lord, 497 of today's list. This is, my lord, contempt application relating to water connection. My lord, in spite of your lordship direction, my lord, petitioner is,
Who is your other side?
my lord, I have served the copy, but I, my lord, don't,
Which authority?
my lord, Panchayat. My lord,
Writ also nobody appeared.
my lord, if your lordship kindly fix the matter next week, my lord, then I shall.
All right, next week. Which item?
497.
Application এর ওপর দিকে দিয়ে দেবেন 497.
My lord,
Serve notice.
my lord, can you give me leave to mention for correction my name, my lord? The order was passed on 30 June, my lord, 2025.
Your name has.
Pradut Kumar Das instead of written Pradut Kumar Ghosh, my lord. That
All
is
right,
the-
give. Correction.
My lord, my authorized.
My lord, may I be permitted to
Yes,
mention
sir.
contempt?
If I may mention, your lordship, there are 8 writ petitions, your lordship. The whole urgency is it is against the ED, your lordship, and the ED has illegally attached my bank account. Your lordship, the issue is that the matter is coming on 4th of August on PMA. The pleadings are completed and the matter was supposed to be listed on 7th February 2025 for final arguments, your lordship. Your lordship, however, it has not been appearing, your lordship. We have mentioned it couple of times, but I think even the slip there was some inadvertent error on our part or on your lordship, the slip was not there, your lordship. Your lordship, there are 8 connected writ petitions, your lordship, which is
Yes.
1767 in the list, your lordship.
Yes.
Up for appearing, for hearing, for final hearing, your lordship. If your lordship, before 4th of August, if the matters, if these 8 writ petitions can be taken, otherwise, your lordship,
Is it appearing in the appearing in the hearing list?
it's appearing in the hearing list.
We'll take up hearing matters.
Lord, may I have your lordship?
Lordship, if your lordship
Follow the list.
May I have your lordship's kind leave to mention, my lord, item
Slip
number,
is not required. If it is there in the list, do not
lord,
give the
item
slip.
number 154 of your lordship's daily list, my lord. The urgency is, my lord, this matter is in regard to, my lord, the fire incident which happened in Orphanganj market at Khidirpur. My lord, the petitioner is, they are the allotee of other shop rooms, and the fire affected, the KMC authority is trying to, my lord, relocate the fire affected traders at my place. My lord, after filing of the writ petition and after serving of the writ petition along with all annexures, the KMC authority, my lord, came and trying to dispossess me and demolish the shop, the existing.
Then why are you here and not before the KMC bench? This is not the KMC bench. This is not the KMC bench. Yes.
My lord, may I be permitted to mention one contempt application?
For what?
Inclusion.
Today is not the day to mention for
The
inclusions.
state
My lord,
authority
why
are
they will
the
have
answering
leave to file an application. It's an addition of party in an original side matter, my lord. My with the short case title, the writ petition and the contempt petition has not been served. I would be allowed to affirm the petition, but the department would not allow me to file the application since there's a short cause title. I have not been served. I don't know the cause title. And a leave is required. I have given the cause title after
So what you want? Addition of party?
for addition of party, my lord.
Yes.
My lord, I have the short cause title with from the cause list. I've printed the cause short
Who's in the original side?
in the original side matter.
And who is your other side? The matter is appearing in the list.
It would be returnable before my lord tomorrow, my lord. The application,
Tomorrow.
the contempt matter. It's that matter where Mr. Ghosh was appearing and Mr. Vishwarup Bhattacharya was appearing for the developer.
If you say that way,
No,
it's impossible to memorize
no,
and
my lord.
recollect
I bow
who
down.
is appearing in what matter.
I bow down. My lord, yes.
Give the cause title so that he can file it.
My lord, I would not have trouble your lordship, my lord. I am troubling, my lord. The state authority, the state respondents are also there, my lord, who are also the answering respondents, my lord. If your lordship pleases,
But if you say that you are aggrieved by the order of the corporation,
my lord, there is no order of the corporation, my lord. There is a combined action by the state of West Bengal as well as the corporation authority, my lord. They are trying to dispossess the petitioners. That is my case. The state authorities are also the answering respondents, my lord. That's why I am.
and
Item number 154, my lord.
154.
My lord, on 5th of July, an attempt was made, my lord, on the very day, my lord, the petitioner approached the police authority.
Next Monday, it will appear served notice.
My lord,
Urgent motion.
my lord, may
It's not required.
My lord, may I be permitted to mention one matter, my lord? This is regarding illegal filling up of land and unauthorized construction on the land.
Illegal filling up of land or water body?
Water body. Water, wetland, my lord,
Wetland.
Wetland. I stand corrected, my lord. Initially, I had filed a appeal application, my lord, before the Honorable the Chief Justice. The Honorable the Chief Justice has been pleased to pass an order directing that this matter be treated as a writ petition under Group 9 to be placed before the appropriate single bench having determination. My lord, I went to the department to be enlisted to get this matter enlisted. My lord, since the suffix of this matter is WPAP, your lordship, the department is saying your lordship's requisition is required to the department that this may be converted to WPA. Thereafter, it can be listed. I was seeking your lordship's leave if your lordship's
Where
officer
is the
sends
file?
My lord, it is in the mandamus department.
Give the number.
My lord, may I give
To be
the...
mentioned. To be mentioned, it will appear requisition the file.
I'm grateful, your lordship.
My ladyship, may I be permitted to mention a matter? It's an urgency application that I have filed connected to a writ petition. That is item number 1589 on my ladyship's list. My ladyship, the urgency is that I am a micro company and I supplied some orders to the ordnance factory. Now, there were some disputes regarding the same, and there's been an arbitration that has been going on with the West Bengal Facilitation Council for the micro and small companies. The first arbitration sitting was in 2021 and the second was in 2023, and it's still pending. There's no proceeding in that arbitration matter. If my lady would please hear the writ petition that I have connected to.
What is the urgency that has cropped up today? The matter was there in the list, combined list.
Yes.
It is there for quite some time.
Yes, my lady.
Mentioning were allowed.
My lady, the urgency is that I have been surviving on my savings and my bread and butter is on the line now.
Next day when mentioning is taken up, please come.
Lordship, may I mention one matter, original side matter? Lordship, leave was granted to mention this matter before your lordship for inclusion in the list under the heading hearing after exchange of.
There are a lot of hearing matters. Please do not mention now.
Lordship, may I
Let it be included in the next one.
restoration application, lordship.
You want inclusion? Today is not the day.
May I be permitted to mention item of 523, my lord, appearing as under heading application, my lord.
Yes.
My lord, urgency, my lord, last 3-4 years, my lord. Last 4 years, my lord, application for registration of the petitioners association.
No, it's a contempt matter.
Application, my lord.
Application. Yes. Who is your other side?
Animesh Mukherjee.
Bring your other side.
Lord.
Call the list.
What did I appear for the petitioner?
Yes.
Let me come back to my lord. This is that contempt matter in which, my lord, the corporation was not really passing any order, although there was a final finding by your lordship that there was unauthorized construction.
6.
My lord, just to refresh your lordship's memory, kindly see
There was
your
a direction
lordship.
upon the contempt number 4 to remain personally present. Corporation, is he here? Who is he? Who is he? No, I have seen. Who is he? Who is he? What is his designation? Erstwhile executive engineer. All right.
No, my lord will see my lord's last order, where my lord has been pleased to clearly record the fact that, my lord, they are really sitting over the matter and not doing anything. Now a report has been filed on the last day pursuant to your lordship's kind order.
Yes.
They have circulated a copy of the report. My lord will kindly take a report.
Yes.
I'm amazed, my lord, how they could have passed this order
All right.
in spite of your lordship's express finding that there is unauthorized construction.
All
First
right.
page of the report I'm not going into.
Hmm.
Kindly come to the third paragraph. The Director General Building, along with Executive Engineer, submitted a report on 1/7/2025 before me. It appears from the said report that notice was issued under sections 401 and 416 of the KMC Act was issued by the concerned borough after detection of the unauthorized change of use and followed by raising of unauthorized construction on 9/9/23 against the person responsible for rendering such illegal activity. The unauthorized construction of the said premises, as per the report, appears at ground floor by making a fiber shed structure at front side of shop, followed by change of use at first floor from shop room to office room, second floor and third floor from residential to office building. Thereafter, the matter was placed before the Special Officer Building to conduct the proceedings under section so and so. But I'm not placing the rest of the paragraph. Kindly turn the page. The The said order was communicated to the person responsible as it appears from the said report that in non-submission of documents as per order of Special Officer Building, the matter was placed before the Mayor and Council for necessary direction, wherein Mayor and Council, read item number so-and-so, referred back the matter to the file to Special Officer for comprehensive and immediate rehearing due to non-submission of critical documents like clearance certificate from WBFES and structural stability. That in view of the direction of Mayor and Council dated so-and-so, Special Officer Building conducted rehearing of the matter and an order was passed on so-and-so, duly approved by Mayor and Council this so-and-so. That in the said order of Special Officer Building, direction in a nutshell was given to remove the fiber-shaded structures in front of the shop room said unauthorizedly. Pausing here for a moment. There was also a brick wall with a room which was recorded by them as unauthorized. There is no reference to pulling down that wall which contains the big room. But kindly see, the change of use at the first floor was allowed on payment of fees under section 401 and 416 of the KMC Act. My lord, regularization has been, my lord, discussed in length by the Supreme Court, and they have found it to be a reprehensible act which should not be allowed to be paid by the respective persons responsible for the said portion of the ground floor, second floor, and third floor due to non-submission of NOC from WBFES, and such change of use was not allowed. The department further reported that the said order was duly communicated to the person responsible along with the petitioners. My lord, kindly turn.
So first floor regularized, second and third due to non-submission,
My lord,
not allowed.
kindly see, my lord, the real report, which is the next annexion. The second page of that document. Part A of the order states to remove the fiber-shaded structure at front side of the shop within a period of 30 days from the date of communication of the order, failing which action will be taken by the department. Nothing about the room, but it follows next. Part B of the order states that the change of use from sanctioned showroom to office at first floor may be allowed on payment of fees under so-and-so, section so-and-so, to be paid by the respective flat owners within a period of 30 days from the date of communication of this order, failing which action may be taken. The room measuring 6.353 into 5.06 at the ground floor, shown in sketch, may also be allowed to retain on payment of fees to be paid by the respective. And my lord, in this report later on, there is recording that details of unauthorized construction, brick walls at ground floor covering entrance lobby to the room, fiber sheet roofed structure at ground story covered front space, open space. So, my lord, kindly see part C also now. Let me, for the sake of completion, part C of the order states that no change of use will be allowed at ground floor, second and third floor, that due to non-availability of NOC. So, my lord, what is the scope and purport of this order? I am regularizing certain parts in spite of your lordship's direction and finding that they are unauthorized. And there is a apprehension on my part, which is borne out by their report, that they will regularize everything after those documents are produced. Well, kindly allow me to place your lordship's order, in respect of which, my lord, we have come up by way of contempt.
No, there was a direction upon the authority to deal with the unauthorized construction in accordance with law, right? Now they have gone to
it was all
unauthorized.
And they have been, instead of only for removal of the fiber shed, my lord, they have regularized everything.
Yes.
It's a clear case of contempt.
Not regularized.
Well, kindly see the writ petition.
No, but then I can follow it. But then sitting in contempt jurisdiction, going into the merit of the matter, the Supreme Court is not permitting.
My lord, I am not asking your lordship to go into the merit of the matter, my lord. With the deepest of respect, I submit. Your lordship's order is very clear. My lord, kindly read your lordship's order. Page.
No, the court has
My lord, may I
noticed that the authority has detected unauthorized construction.
Yes, and still they are not removing it. So, my lord, in my humble and respectful submission, my lord should direct them to abide by this.
Thing is, the law, there is a provision for regularization in the law.
No, my lord, kindly
There is
just one judgment. My lord, since my lord has been so gracious, my lord, to
But then will it be proper to look into the details of the order that has been passed
Yes,
in
because it
a
has been recorded
contempt?
in your lordship's order. My lord,
No, in the contempt jurisdiction, in a writ petition, you come up with all this, it is all right. it can be gone into.
My lord, kindly, I just read out page 32 of the main writ petition. A report has been filed by the engineers of the Kolkata Municipal Corporation. It appears therefrom that the corporation sanctioned a building plan for construction of G+4-story building. The same was modified, regularized twice. Twice it was regularized. Now they are paying, my lord, they've been allowed to pay again to regularize certain things. On
You
5,
please
5,
show me. You please show me some judgment from the Supreme Court which permits the Contempt Court to look into the legality and the correctness of the order that has been passed by the authority.
My lord, we have
Contempt.
we have judgments from the Supreme Court which say, my lord, which condemns any form of unauthorized construction being sanctioned, and it should be dealt with iron hands. My lord, that is very clear. But today, in contempt, my lord, if my lord finds that an act of contempt has been committed and your lordship's order has been consciously and deliberately and contumaciously violated, your lordship has the power either to punish the offending officers in accordance with the law, or direct, my lord, that the acts of contempt which have come up and which have not been removed in spite of your lordship's order should immediately be removed. So today, their report clearly shows, my lord, that they themselves are not acting in terms of your lordship's order in spite of holding that it is an unauthorized construction. Well, just allow me to place one paragraph of one particular judgment of the Supreme Court. 20. Paragraph 20.
Paragraph 20.
Just give me a moment. Paragraph 20.
Page 21.
Paragraph 20, 2024 SCC Online Supreme Court 3767. My lord has found paragraph 20.
Which page do I get that?
Page 21.
Page 21, my lord, my learned junior says of the judgment that my lord will find on the left-hand side on the top.
And para 20.
And para 20 is on
Page 21, paragraph 20, yes.
in the ultimate, the law is discussed.
Hmm.
Then, in the ultimate analysis, we are of the opinion that constructions put up in violation of or deviation from the building plan approved by the local authority and the constructions which are audaciously put up without any building planning approval cannot be encouraged. Each and every construction must be made scrupulously, following and strictly adhering to the rules. In the event of any violation being brought to the notice of the courts, it has to be curtailed with iron hands, and any lenience afforded to them would amount to showing misplaced sympathy. Delay in directing rectification of the illegalities, administrative failure, regulatory inefficiency, cost of construction and investments, negligence and laxity on the part of the authorities concerned in performing their obligations under the Act cannot be used as a shield to defend action taken against the illegal unauthorized construction. That apart, the state governments often seek to enrich themselves through the process of regularization by condoning and ratifying the violations and illegalities. The state is unmindful that this gain is insignificant compared to the long-term damage it causes to the orderly urban development and irreversible adverse impact on the environment. Hence, regularization schemes must be brought and only in exceptional circumstances and as a one-time measure for residents' houses.
Residential houses.
After a detailed survey and considering the nature of land, fertility, usage, impact on the environment, availability and distribution of resources, proximity to water bodies, rivers, larger public interest. Unauthorized constructions, apart from posing a threat to the life of the occupants and the citizens living nearby, also have an effect on resources like electricity, groundwater, and access to roads, which are authorized activities. Master plan of the zonal development cannot be just individual centric, but also must be devised keeping in mind the larger interest of the public and the environment. Unless the administration is streamlined and the persons entrusted with the implementation of the Act are held accountable for their failure in performing statutory obligations, violations of this nature would go unchecked and become more rampant. If the officials are let scot-free, they will be emboldened and would continue to turn a Nelson's eye to all the illegalities resulting in derailment of all planned projects and pollution, disorderly traffic, etc. Well, just turn the page. 6. No permission license to conduct any business trade must be given by any authorities, including local bodies of states, union territories, and any unauthorized construction building, irrespective of being a residential or commercial building. The development must be in conformity with the zonal plan, etc. Whenever any request is made by the respective authority under the planning department local body for cooperation from another department to take action against any unauthorized construction, the latter shall render immediate assistance and cooperation in delay. Well, these are general guidelines, my lord, which is laid up, which includes, my lord, your lordship's jurisdiction in the contempt jurisdiction. So today, there is a finding of unauthorized construction. There is a direction to take steps in regard to the unauthorized construction. Today, my lord, regularization by their own admission has happened twice. And in spite of that, and in spite of holding that the fiber shed is bad, the wall is bad, these rooms cannot be changed, everything is regularized and just one measly fiber shed is allowed to be removed. Well, the Supreme Court has again, my lord, in the case reported in 2025 SCC Online, Supreme Court 995. Kindly grant me a moment.
Internal page 3.
Paragraph 6.
Internal page 3.
Internal page 3. My lord has found it, my lord. I'm sorry.
Paragraph?
Paragraph 6.
6.
The learned counsel
Yes.
appearing for the petitioner would submit that a client be given one chance to pray for regularization of the unauthorized construction. We do not find any merit in such submission. A person who has no regard for the law cannot be permitted to pray for regularization after putting up unauthorized construction of 2 floors. This has something to do with the rule of law. Unauthorized construction has to be demolished. There is no way out. Judicial discretion would be guided by expediency. Courts are not free from statutory fetters. Justice is to be rendered in accordance with law. We are at pains to observe that the aforesaid aspect has not been kept in mind by any state government while enacting regularization of unauthorized development act based on payment of impact fees. Thus, the courts must adopt a strict approach while dealing with cases of illegal construction and should not readily engage themselves in judicial regularization of buildings erected without requisite permissions of the competent authority. The need for maintaining such a firm stance emanates not only from the inviolable duty cast upon the courts to uphold the rule of law, rather such judicial restraint grants more force in order to facilitate the well-being of all concerned. The law ought not to come to rescue of those who flout its rigors, as allowing the same might result in flourishing the culture of impunity. Put otherwise, if the law were to protect the ones who endeavor to disregard it, the same would lead to undermine the deterrent effect of laws, which is the cornerstone of a just and orderly society. So here, my lord, at the risk of repetition, they violate. Your lordship holds, my lord, that it is unauthorized construction. They are asked to take steps. They do not take steps. This is the 3rd or 4th time we are coming up before your lordship. It was because of your lordship, my lord, that the matter was expedited. And now what do we find? The violation has been regularized without them asking for it. The corporation itself has violated it. But I would humbly and very respectfully submit to your lordship, my lord, kindly take a very strict view of the matter and kindly, my lord, direct them to regularize, no, not to regularize, but pull down all unauthorized construction. Part C of their report, my lord, is understandable if they file a compliance report, which says, part C, just a moment, which I was placing before I came up till part B. Part C. The orders, C of the order states no change of use will be allowed at ground floor, 2nd and 3rd floor due to non-availability of NOC from WBFES except 1st floor. So, my lord, that room is regularized and then they say there will be no change in use. Kindly see the dichotomy of the situation. A, B, C, a direct assault, if I may use that word, my lord, on the further directions of your lordship, my lord, to pass an approved order. Even in the report, my lord, they themselves, everything, if my lord goes through the report in detail,
Previously to ground floor was and total more than 50%.
total sanctioned area, my lord, I reached from an annexure in the report. I'm not troubling your lordship with this. Just kindly hear me once. Previously, ground floor southern portion was used for restaurant in place of lobby. Now ownership has been changed. Present not used for restoration purpose, only renovation work has been taken up by the owner. Hence, there is only a room bounded by brick wall, which has been held to be unauthorized by them in a previous report. And your lordship has also held it to be unauthorized. Total sanction covered area is 1172 square meters. Now area of 744 is used as commercial purpose other than residential. So more than 50% area is used as commercial purpose. Principal occupancy of the building is changed, for which NOC from WBFNEC is required. There is no massive unauthorized construction. Issues are related to change considering the documents Part A, Part B, Part C.
Last page of it.
So, my lord, in this background of the state of affairs and in view of the observations of the Supreme Court, I dare say, my lord, your lordship has the power and the jurisdiction to take an iron hand, because it is not just once when we came up before your lordship, my lord, complaining against the order. It is even
Very
after the order
yes.
and the dealing of the matter, my lord.
Well, with
that
my
the-
knowledge about the contempt proceeding, Lord, I respectfully submit, my lord, that my learned friend cannot go into the question, the correctness of the validity of the order which has been passed in terms of a lordship direction. Your lordship has to examine whether in terms of a lordship's order that has been acted upon or not. Because there are other forums to question. For a moment, I am not submitting to your lordship with regard to the correctness or validity of the order which has been passed by the special officer building. Because he has certain powers, he has exercised. Now that if the order is bad, there are other forums to go ahead. Because the ultimately, my lord, it may come before the High Court again, my lord, regarding the validity of the order. After the order being passed by the learned tribunal, then my lord, division bench, all these issues are there. Therefore, I am not, my lord, for a moment, my lord, going into the issue, the correctness of validity, how it has been ordered passed, whether it should remain or not. Because this is not my, because that is, my lord, your lordship will consider. Because I may submit that your lordship passed an order that the concern is that is the report which has submitted with the petition of filed, taking the inaction on the part of the Kolkata Municipal Corporation. That inaction your lordship took into consideration, and your lordship directed the executive engineer to deal with the unauthorized construction and which has been detected, and after giving reasonable opportunity of being heard, then it is to be disposed of in certain period. Yes, fact, that period has been maintained. But for the fact, after that, the matter I submitted to your lordship that after the initial order was passed by the special officer building, it was sent back to the, it was forwarded to the mayor and council. He, my lord, on certain views, my lord, returned the matter back to the special officer building again. Now the order has again been passed. Now the order has been passed, my lord, so far as your lordship is concerned, because your lordship has not directed that it is to be, my lord, demolished or something in a particular manner. It has to be, order has to be passed. Because order has been passed in disposing of the direction of your lordship. Now,
The thing is that you were directed to deal with the unauthorized construction in accordance with law.
Right.
This is the order that is being passed. And
This is 6 June order.
it appears from the order that the unauthorized construction was detected.
right. Because the detected, that is the reason proceeding was initiated.
Proceeding was initiated.
Right.
Now the Supreme Court says that you cannot do it.
I'm not going into the Supreme Court decision right now.
You have to, because this has
I'm
been
not going
placed.
in that process. If it is said, then your lordship said that in view of this order that no, the constructions to be allowed to be retained. That's one of the matter my authority will consider accordingly. But my lord, when the power has been given the retention or no retention, because there is divergence of the views of the Supreme Court, High Court, and many matters. Therefore, my lord,
This is the judgment that has been placed
your
just
lordship
now.
cannot, in my response submission on that basis, your lordship cannot right now say that in terms of your lordship, that order for which the violation has been complained of, because of that order, I am to pass in view of that Supreme Court order that
it is to be demolished. But that possibly in my sufficient limited knowledge, that possibly cannot be passed because that could be examined by the learned tribunal once again because I have committed wrong. I'm taking it that I have a mistake that I have not taken note of the order because that is not your lordship direction that to pull down the another construction.
Order was to deal with the unauthorized construction in accordance with law.
Ethical is dealing with that.
Right.
But I have exercised my wisdom. But I have exercised my wisdom, maybe right or wrong. Then your other forum is there to correct me. They can pass in order, setting aside my order. But
So
showing my order, my lord,
is it your case that a litigant has to move from one forum
One
to
forum
the
to one
other
forum,
only
that is
for
not
the
the issue. One
purpose of
forum
getting
to
relief?
another point is not the issue.
So that is
Because
the issue.
scheme has been framed under the act. The scheme has been framed under the act. That initial order to pass an order. That if that order is considered to be bad, my lord, one has the right to prepare an appeal. Therefore, he will go prepare an appeal.
That means he'll go, he files a writ, not complied, again a writ, not complied,
No,
then a
this
contempt,
is the only order.
not, there is nothing done. Now you come up and say it has been regularized.
What is the number
The
1,
court-
1 to 3 writ petition? That is only one writ petition.
All right, then a contempt.
Well, the contempt is there. Your lordship is looking at that your lordship has the order has not been in consideration of that, it has been disposed of. Therefore, when it has been disposed of, I submitted to your lordship at the earlier occasion that since there is a regulation matter was sent to the neighboring council for the approval or non-approval, it has been initially not approved and sent back the matter to the. Therefore, I have altered and whatever I consider, my lord, having regard to that, my lord, the forwarding the matter back to me, well, I have passed an order. Now, my lord, he has the right to prepare an appeal, but he is asking that on the merit of the order of the special officer building, that your lordship should pass an direction for the demolition. If your lordship thinks that order could be exercised, that power could be exercised in that way by the in exercising the power in content, my lord, you should pass an order. Then I will demolish the structure. Now, there is nothing to say we are saying the matter because I am not saying that whether the Supreme Court order because proposition of law Supreme Court has laid down. Not only there are divergent views also of
Would you like to place any divergent view?
I am not placing before a lawsuit in a contempt matter because I will be submitting to a lawsuit jurisdiction on the merit of the order. But that I will not do consciously. I will not do it.
Well, it cannot be done in a contempt matter. Would you like to produce some judgment?
Well, contempt matter, but I am submitting. It has been complied with. You will pass an order.
All right. Very well.
Merit, I will not go into the issue right now.
Well, I appear for the
Not on the merit of the order that
Not
has
only
been
merit of
passed.
order, but I am submitting, my lord, when an order has been passed, my lord, the court has said, my lord, when the order has been passed, my lord, the court, my lord, they will not proceed with a further order, which is not in the parent order. That is your lordship knows, my lord. It is not to be said by me before your lordship.
No, you can place judgments because when it has come,
this is the view.
when this has come to the court,
This is the view of the court. Your lordship, my lord, considers that your lordship could go further, my lord, over and above that order. Because of the order has been passed, your lordship will pass an order. And I submit to your lordship, have there been any order of your lordship, my lord, direct order for demolition, I will execute that order.
Malad, I appear for the contender number 6. I am the present owner of the ground floor portion of the premises. Malad, I have a few facts to place, which I have not had the opportunity because it's the first time, Lordship, that we are appearing in this proceeding. We've not been served with a copy of the contempt as of now because Lordship had directed the contempt application to be served only upon the contender number 4 and no one else.
Right.
However, since my rights are being affected, Lordship, and I've been made a party in the contempt proceeding because I was not a party in the writ petition. Even though my rights were affected, I had appeared upon coming to know of the proceeding, I had appeared before your Lordship, and Lordship had permitted us to raise the issues before the corporation. We were given a limited chance of making our representation before the corporation, which we did. Now, Lordship, this order has been passed, contempt has been filed, and I've been made contender number 6, but I have not seen what is there in the contempt application. But going by the submissions, Lordship, which I've had the occasion of hearing, it appears that going into this aspect could be beyond the jurisdiction within the contempt field. However, if your Lordship is minded to go into the matter, Lordship will kindly direct a copy of the contempt application to be served on me and permit me an opportunity of placing forward our view, our narration of facts, because there's clearly something which has not been placed before your lordship. And may I just indicate in very short, I'll place it, if lordship gives me the opportunity, I'll place the correct facts. My lord, this entirety of this commercial, residential, this all emanates, lordship.
The court is not minded to hear you now.
Yes.
My lord, because my rights will be affected and there are certain facts which need to be brought to my lord's notice, which have not been placed by the petitioner.
You have been heard by the special officer?
My lord, we were given...
You made all submission before the special officer?
Lordship.
Why will the court hear you now?
My lord, because in the contempt proceeding, lordship, what is being sought to be done is really affect my right. Since I'm been arraigned as a contemner, and since lordship the proceeding will be between the court and the contemner, I was humbly submitting, lordship, before any part of my portion is demolished or any order is passed or my right is affected in any manner, if my lord kindly gives us a hearing, because lordship will be passing the order now. I was given 2 days notice to file a representation before the corporation, which I duly did. Even though it was not adequate, we still have our remedies under...
If you have a remedy, you
Lordship,
avail the remedy.
that is a remedy which we'll avail. But
Yes.
since we've been made a contemner, and if lordship is passing any order considering the merits of the order, then lordship will kindly hear us, because my right is being affected. This discussion which is happening, it will neither prejudice the petitioner nor the corporation. It will prejudice me, which is why I'll ask for an opportunity, because the foundational fact is this. This entire dispute is created by the petitioner's father. All these misrepresentations were made by the petitioner's fathers. He sold these premises
Listen,
as
the
commercial
court-
premises.
The court is only concerned to see as to whether the unauthorized constructions are removed or not. Nothing else.
Lordship, to
If
that,
it is unauthorized, it is unauthorized. Be it you, be it his father, be it
Lordship.
his grandfather, the court is not concerned.
Lordship, I bow down to that, lordship.
It is only this.
My only submission is that before lordship passes an order in respect of the unauthorized construction, lordship will kindly give us a hearing, because we've been arraigned as a contemner, and lordship would just give us an opportunity of being heard.
No, there was no direction upon you. I do not know why they have arraigned you, but thing is, the direction was upon the corporation to deal with it.
Lordship.
Now, how the corporation has dealt with it, whether it is in accordance with law or not, that is to be seen. Nothing else.
To that extent, lordship,
You have your own remedy, avail it.
Lordship, but in the contempt, at least, if we are at least given a chance of being heard on the issue of whether it's unauthorized or not, or
That
to what
is not
extent.
the issue.
Lordship.
The fact that it is unauthorized
Lordship.
has already been brought on record. Now, if you are aggrieved, you challenge it.
Lordship, I bow down to that, lordship. Now, lordship will kindly appreciate the factual situation. I have a remedy. I may file, I may go before the appellate provision under the KMC Act, or if the order is bad, patently bad, I fall within the exceptions, I can file a writ petition. Now, lordship, in the meantime, if your lordship, assuming, decides to go into the merits of this order, and lordship comes to a finding that the corporation, following lordship's order of 14 September 2023, they should have demolished it. Now, if that order of demolition is passed, my remedies which I may invoke will really become infructuous.
Go to the appeal court.
My lord, but in that case, to prevent that multiplicity from lordship happening, at least give us a chance of being heard in the contempt proceeding.
I do not feel there is any reason to hear you, because my direction was strictly upon the corporation, and the corporation should deal with it.
My lord, but the direction was also to hear all parties.
If they have not heard, your right has been affected, take steps.
Lordship, but in that case, if lordship passes an order, let's say of demolition in this contempt proceeding, then what remains of my other remedy to approach, lordship? Then it will become an illusory remedy for me.
I cannot help.
Because the corporation, the appellate tribunal of the corporation cannot go beyond any order passed by your lordship. Even if I file a writ petition, lordship, your lordship's order being of a coordinate bench will be binding. Therefore, by the time I invoke any remedy, nothing will be left in the matter.
Anything in reply?
Well, just two things I want to point out. It'll take 1 minute. Your lordship's last order, 12th June 2025, paragraph 3 onwards. Records reveal that the court directed the corporation to take a decision on the detected unauthorized construction way back on 14 September 2023. Till date, the unauthorized construction remains, and the file relating to such unauthorized construction appears to be moving from one table to the other. No work appears to have been done practically. The act of the corporation tacitly supports the unauthorized construction that has been detected. The unauthorized construction gets extra lease of life due to such dilatory attitude of the authority. Such stand of the corporation is absolutely contrary to law and highly deprecated by the court. Unauthorized construction ought to be dealt with an iron hand without showing any mercy to dishonest builders. The contender number 2, the Municipal Commissioner, Kolkata Municipal Corporation, is directed to file a report before this court, clearly disclosing the reasons for supporting the unauthorized construction by not taking positive steps to remove the same for such a long period of time after the unauthorized construction was detected by the officers of the corporation. So, my lord, once again, my lord, in blatant disregard of the order, your lordship has seen what has happened. It has been regularized. And secondly, my lord, I heard my learned friend, Mr. Ghosh, speaking for the corporation that he can go and take steps he can prefer an appeal. I can't prefer an appeal. It is only, my lord, the person who's responsible for the illegal construction who can prefer the appeal. I haven't made the illegal construction.
No, any person aggrieved.
No, my lord, there is a division bench judgment of this Honorable High Court.
All right. What does it say?
Para 16. It is in আপনার petition. It is your copy. Para 16.
Para 16. My lord has found it. Keeping the aforesaid observations of the Honorable Apex Court in mind, as regards the first question as to who should be granted a reasonable opportunity of showing cause before a demolition order is made by the corporation under Section 401 of the KMC Act, I'm of the considered view that it is only an owner or occupier or any other person who is responsible for the impugned construction who is entitled to such an opportunity. This is because the explanation appended to Section 401 defines the phrase, the person at whose instance, as the owner, occupier, or any other person who causes the erection impugned or raises such erection himself. It is an exhaustive definition. It is not an inclusive definition. The explanation clarifies the phrase that a person at whose instance used in Section 401 means. There is no ambiguity in the language of explanation. Indeed, if one thinks logically, why should anyone else, excepting the person who has made or has caused the impugned construction to be made, be granted an opportunity of showing cause as to why the unauthorized construction should not be demolished? That person may be the owner or occupier or any other person, example, developer. I see no reason why a subsequent purchaser or a transferee of the illegal construction or a tenant, a licensee in occupation of such construction, a portion thereof, or any other person not responsible for the impugned construction should be granted an opportunity to show cause as to why the illegal construction should be removed.
But this is something different from possibly what is your grievance and what is your right.
Well, then let us assume for a moment my lord does not look into this judgment. I go back to my original stand. I have, my lordship,
yes,
an order.
That
there has been violation of that order.
Right.
I have come to court. My lordship gave certain directions. The violation is accepted and admitted by them in writing in at least 3 several reports filed before the contempt proceedings. When your lordship passes the order of 12th June, it goes back to the commissioner. The commissioner, my lord, sends it back to the engineer. And the engineer makes matters even worse by saying, I regularize it, only remove one fiber sheet.
Yes, I followed it.
Please kindly deal with it, my lord.
Heard submissions made on behalf of the petitioner and the corporation. Stop. Learned advocate representing the one Sarika Tiwari.
Lodge. Contender number 6, Lodge.
Pleaded as the contender number 6 in the contempt application. Seeks to make submission. Stop. The court sitting in contempt jurisdiction is not inclined to hear the said respondent. The court is only minded to ensure that the order of the court is followed by the contemners. Stop. Next. List the matter for further for orders on 18th of July.
I'm grateful to my lord.
The special building is present in lawsuit order, my lord.
Yes.
Is to
The contempt number 4 is personally present in court. Stop. Why was he not present on the last occasion and without any explanation?
That information did not come, he could not come, my lord, because of traffic jam on the way. He came, my lord, at a later stage, my lord. Of course, I should have come to lawsuit court and report to lawsuit that he has come late. But
You
at
did
the
not.
time of, my lord, matter was taken up.
The court has a time
That has
and
I bowed down to you, Lord,
it
because
has to be followed. This is not an
he was
explanation.
On the way, my lord, I told him he was on the way, my lord.
Somebody else came in his place and you say he was on his way. The court was not even informed.
Number 4 is personally present in court.
Yes. The explanation given by the learned advocate within bracket held up in traffic jam. For not appearing on the scheduled date is not appreciated. Stop. For the time being, the personal appearance of the said person stands dispensed with.
Grateful, man.
চেষ্টা করো অনুসারে না বলছো না
Lordship, so far as item number 7 in original side is concerned, Lord, I have certain urgency in the matter.
What
Lord,
is it?
Lord, it is against an order passed by the Bar Council, my Lord, from, Lord, I cannot pass, my Lord, appear before the court. Lord, there is a flagrant violation of natural justice. My Lord, what happens is that, my Lord, inter-pleadings has been filed.
Very well. It is there in the list. It will be taken up. Don't worry.
Lord,
My lord, maybe one indulgence, item number 3, at least on 2 occasions I took time, my lord. Today itself, Mr. Banerjee is sitting. My lord, lordship is it possible, my lord, to take up this matter?
It's already 11:45.
The matters will run in the
Mr.
list
Banerjee.
tomorrow.
Mr. Banerjee is, my lord, waiting.
Why to be mentioned? Why? Non-prosecution. The release nine. Release and non-prosecution are two simply different. Pass over.
That I am for the petitioner. Lord, this is my affidavit of service.
Yes.
Well, let the petitioner before your lordship, my lord, he is a permanent resident of Bhubaneswar. My lord, he was, my lord, the CEO of a company which was, my lord, registered and operating in Bhubaneswar. My lord, there was IBC proceedings against the company, my lord.
Anybody appearing?
My lord, I appear on behalf of the respondents for the SFIU.
Yes, SFI. My lord,
I'm led by my senior Ajit Kumar Chaube.
My lord, the company where, my lord, the petitioner was a CEO, my lord, there was an IBC proceedings against it and an RP was appointed. The RP has taken over the company. Now, my lord, whenever the petitioner, my lord, intended to travel outside India, my lord, he was stopped in the airport, purportedly on the ground that there is a lookout circular against him. My lord, till today, my lord, despite several representations, my lord, the lookout circular has never been served on me. My lord, similar, my lord, treatment was meted out to my brother, my lord, who was also, my lord, in that company when he was traveling abroad. Now, my lord, I have made representations from time to time, my lord, requesting them to at least communicate me the lookout circular and have communicated to me the background under which the entire thing has happened. My lord, everything is in Odisha. The only thing that is here is, my lord, the SFIO's office from where I am being, my lord, summoned. My lord, in fact, my lord, in response to the summons that was served on me, I have appeared before, my lord, the SFIO. I have complied with the, my lord, summons.
Show me one of the summons.
Lordships. My lord, the summons, my lord will find at, my lord, page, my lord, kindly have, my lord, page 163. Kindly have, my lord, page 163. It is a summons, my lord.
There are 2 page numbers or what?
My lord, it is, they have done it in a unique way. In total, there are 183 pages.
All right.
They have
It's
done
not
it like that.
63. I get it.
Well, it's annexure P10, my lord.
All right.
Kindly see, my lord, on the top, the address of the office from where they are conducting this investigation. This is in
Yes,
Kolkata, my lord,
please.
Esplanade. My lord, about third paragraph of this notice, summon, my lord, your lordship will find my name, Sunil Kumar Agarwal. And I was asked, my lord, to appear, my lord. And, my lord, I go and comply with this on 8th of April 2025, which, my lord, your lordship knows, my lord, they ordinarily do not endorse it on the face of the summons, but whenever their office is attended, my lord, we sign on the register. And, my lord, additionally, my lord, by way of abundant precaution, at page 165, my lord, I, my lord, record everything that was questioned to me and that I responded to during the course of my, my lord, attendance on 8th of April 2025. Your lordship will see we have done it in a tabular manner with regard to the questions and the answers. And, my lord, I had sent
questionnaire. Was it given to you?
questions where, my lord, asked to me. My lord, I have recorded that.
How could you record it?
No, from my mind, my lord, I could, my lord,
So,
whatever I recollect, my lord, the reason why we have placed this on record is to record that I had attended on 8th of April. Nothing more, my lord.
All right.
My lord,
Nothing more.
my respondent, similar.
And,
Let
my lord,
them make submission.
and, my lord, as of now, my lord, my only predicament is I not only have the copy of the lookout circular, but earlier also, my lord, I have been unable, my lord, to travel. My lord, earlier also when I went to travel, I have not been able to travel. My lord, kindly have, my lord, I wanted to go to, my lord, Bangkok, my lord, for personal work, for professional work, my lord, at page 176, my lord will find the tickets. I was not allowed, my lord, to go through the immigration, my lord, on the ground that there is an LOC issued. Then, my lord, at page 177, after I was refused to, my lord, go through immigration, my lord, I wrote, my lord, to the SFIO, and I said that kindly withdraw the LOC because there is no, my lord, justification, my lord. The company where I was the CEO, my lord, that company is under the RP. And, my lord, in respect of that company, my lord, we have, my lord, got hold of, my lord, an auditor's report, which, my lord, your lordship will find, my lord, at page, my lord, it's a transaction audit report, starts at page 52. Relevant portion is, my lord, at page 129. There also, to some extent, my lord, it starts at 52, ends at 129.
Yes. Yes.
In 129, my lord will find there is a heading which is described as conclusion.
Yes.
Kindly see the last two conclusions.
Yes.
No transactions were found reportable under this section. No transactions were found reportable under these sections. So, my lord, what I'm trying to indicate to your lordship is that the RP and, my lord, the auditors are looking after, my lord, and they are, my lord, investigating into the affairs of the company. I have been a compliant citizen, my lord, and till today, my lord, subject to correction by my learned friend, there is no allegation from any angle that I have intimidated any witness of their investigation or I have tried to tamper with any document, nothing of that sort. My lord, the limited relief, my lord, that I was very humbly beseeching your lordships to consider is twofold. One is that let them at least provide me the copy of the lookout circular and on what basis they have issued it. And, my lord, kindly allow me to travel, my lord, to Japan from 15th of July to 3rd of August under any terms and conditions that my lord will deem fit and proper. My lord, I have annexed my tickets, my lord, at page 182. I need to go there, my lord, for, my lord, advancement of business. I have made that statement also in para 67. The tickets are at page 182. My lord, any undertaking your lordship, my lord, will deem fit and proper, my lord, we will be furnishing that, my lord, or any stringent terms and conditions, my lord.
My lord, my instruction is that there are 3,500 crores rupees involved. And as per the instruction of the Home Ministry, LOC was
show the LOC.
Lordship, because similar matter has been filed in somewhere regarding the LOC, but they have withdrawn. because this is the testing of the directors. One director is filed there. They know that they will not get it any interim order from the Honorable Court. So that's why they are filed here. Number one, they are not cooperating in the investigation. They are not
cooperating.
Not cooperating, Your Lordship.
All right.
Number one, there is a fair chances to they flee away from the India. No doubt they are the Indian citizen, but they will flee out of the India, and all the money has been siphoned. 3,500 crore rupees involved here, Lordship.
Show the lookout circular, please.
Lordship, today their first day. I give me session to. I will give my objection or whatever report will.
When?
Any 4 weeks, 6 weeks time may be given.
4 weeks.
July
He intends to go out on 15th of July.
This is nothing. This is the IOS. They are different. They have filed the liquidation in the Odisha. This is the two part. One part is they are not cooperating to us in investigation. Number one. Number two, they have for the liquidation gone for in Odisha. So that's why everywhere
Liquidation is all right. Liquidation is a different proceeding. The forum will decide it.
I may be allowed to give some time to give all the papers as per direction of Lordship. I will file my objection.
Let kindly see.
Similar matters you filed in the Delhi High Court.
Show the order. Show the order.
Sir, I will newly appointed.
Delhi High Court. Who has filed? Who has filed? Sunil?
One of the director filed.
No, my lord. Subject to correction at page 174, I have annexed. There was a writ petition filed by Anil Agarwal before this honorable court. It had become infructuous. That is why, my lord, it was withdrawn.
I may give some time given. I further require for the instruction by my department. This is a serious offenses. 3,500 crores are involved. So, and there is 100% chances they will never come to India.
They will never come to India.
They have already siphoned entire money. There is no project. There is no company. There is no their assets here. They are not disclosing all the things. So that's why we at least this stage, this should not be given any relief from this.
On the contrary, everything is in Odisha. Only this investigation they have chosen to initiate from here. The company is in Odisha. The NCLT is in Odisha. NCLT Cuttack bench is in scene of.
Then why are you not approaching the Odisha bench?
Because they have commenced the investigation here.
No, other investigation procedures are also going on.
No. The SFIO office is here. So from here they have initiated the proceedings. My lord, if I go before the Odisha High Court, they will say that the entire thing is in Calcutta. The investigating agency is in Calcutta. The case is, and they have asked me. They have kindly see the summons from where. And from
the summons I can see, but there is serious objection from their side. So without hearing them,
then let them file. And one more thing, my lord, your lordship will very kindly consider their entire, my lord, urgency and objections, my lord, feature only when the matter is before your lordships. My lord, when we had written to them, my lord, on multifarious occasions, requesting them for a copy of the lookout circular, they choose not to give it. Had it been so serious, they could have sent us a one-liner email that there is serious offense and so we will not let you.
The petitioner is being proceeded by the Serious Fraud Investigating Office under the provisions of the Companies Act. Any other provision apart from Companies Act?
No, my lord.
No.
Only the Companies Act.
After that, after completion, then we can impose another.
As on now, it is the Companies Act.
And SFI has the power to act on this.
Oh, nobody is questioning his powers. I want to know what are the other provisions. It's Companies Act. Yes, the petitioner submits that allegedly on the issuance of a lookout circular, the petitioner is not being permitted to move out of the country. Stop. The lookout circular has not been served upon the petitioner and he is not aware of the contents of the same. Stop. The petitioner intends to visit Japan on and from 15th July till till 3rd August 2025. Stop. Apprehending that the petitioner will not be permitted to depart, comma, the instant writ petition has been filed, seeking permission. Stop. The petitioner is willing to give any form of undertaking that may be ordered by the court.
Lord, including any FD, anything, if your lordship desires.
Stop. Learned counsel representing the Serious Fraud Investigation Office seriously opposes the prayer of the petitioner. Stop. It has been submitted that more than 3,500 crores of money have been siphoned off, and there is every possibility that the petitioner will flee the country once any such permission is granted to the petitioner. Stop. It has been submitted that the petitioner is not cooperating with the investigation process. Stop. Prayer has been made to permit the authority to file a report. Stop. Paragraph. Achha. As there is serious objection to the prayer made by the petitioner, comma, the court is unable to grant any type of relief to the petitioner at this stage without affording the respondents to file their report. Stop. The respondents are directed to file a report by way of affidavit disclosing the lookout circular for a bracket S.
LOC materials, if my lord so deems fit and proper, we will provide it in seal cover. Otherwise, we'll state everything or factual. We'll state on affidavit.
LOC, my lord, I am entitled to a copy.
Now, why, what actually?
Disclosing all facts and figures. Stop. The lookout circular be placed before this court in a sealed cover. Stop. How soon can you do it?
Lord, because it will otherwise become infructuous. 4 weeks, my application becomes infructuous.
Yeah, the writ petition becomes infructuous.
Then kindly give me a free order, my lord. I'll furnish any undertaking, my lord. I'll deposit.
My lord, 2 weeks, my lord. We'll ensure.
It becomes infructuous, my lord.
See, your prayer is 15th, it's next week.
My lord, earlier also, my lord,
Today
I have
we are on
been unable, my lord,
10th.
and they have not responded to me.
Well,
They are saying I am not complying. The records say otherwise. They have not procured a warrant of arrest against me. They are not so feeble, my lord, that they can't go and procure a warrant.
My lord, I don't need to arrest the gentleman. I am kindly ensuring that he doesn't go out.
No, sir.
Whatever I have to arrest, whatever he says, my lord, there should be no legal jugglery here.
Disclosing all facts and figures.
Within. Today is 10th. Can you do it by the 18th? 22nd. 22nd of July.
22nd of July. Yes, my lord.
22nd July. Stop. Copy of the report shall be served upon the learned advocate representing.
Will it be, my lord, 25th, my lord? I'm just paying for a benevolence from my lord. No, because I don't want to cut a sorry figure, my lord, because Delhi has to vet it and.
25 তারিখ ঠিক আছে copy of the report shall be served representing the petitioner released for further consideration. Then the urgency goes. You may require it for future use, but then the urgency that you are pleading, because 3rd August you are supposed to come back, it is not possible. In that case, on 12th of August for hearing.
No, my lord, what we'll try to do is, my lord, we'll try to, my lord, reschedule my tickets.
Certainly.
But kindly, my lord, place it, my lord, on
12th of August.
Okay.
Exception to the report may be filed by the petitioner prior to the urgent date.
Item number 3.
I'm grateful.
Deeply.
Is it your matter? Why were you not there when it was called?
They are in court number 8.
You could have kept somebody here. What is it? You want to not
Non-prosecution matter.
show me the letter? Why not prosecution?
Actually, the conflict regarding the payment has been resolved.
Resolved? Relief sought for? Yes. Disposed. Now disposed, now not pressed.
Lordship, I am led by Mr. Rudran is there.
All right. Yes, 3.
May it please, Lord. No, Lordship will recollect on the last occasion, my Lord, I had submitted that this petitioner has come, these petitioners have come with your Lordship, my Lord, challenging memo number, my Lord, which was issued on 17th of June, and along with an order which your Lordship had seen yesterday, my Lord, which your Lordship, my Lord, had said that this is an appealable order. Now, my Lord, the factual matrix, my Lord, which I was
10-3.
Yes, 10-3. Now, these petitioners, my Lord, have been in occupation since last 5 decades, my Lord. As till now, my Lord, there was no problem. Since 2023, my Lord, the private respondent, my Lord, claims that he has purchased a property for which, my Lord, he is facing some problems. He preferred a writ application before this honorable court. My Lord, that writ application came before her ladyship, my Lord, the Honorable Justice Shubhra Ghosh, when her ladyship was going to dismiss, my Lord, on the ground because the civil suit is pending, and this civil suit was filed by the private respondent, and there was an order of status quo because there was an injunction. Now, my Lord, comparing the writ petition, the prayer, as well as the prayer of the plaintiff, my Lord, it had revealed, my Lord, the prayer was same. So her ladyship was.
Are you there for the state?
No, my Lord. I appear on behalf of the private respondent.
State, you are there. What is the instruction?
My lord, I didn't receive till now anything, my lord. My lord, kindly give permit me to take the instruction, my lord, so that
The petitioner will be evicted.
my lord, if may I be just my lord to proceed without my lord. I have to submit, my lord. I get the permission. May I submit my permission?
Thing is, what will be your answer to the eviction?
My lord, kindly just give some time to collect the report.
Try to understand the urgency of a matter, and no, do not make this type of prayer for time and accommodation. When the petitioner faces emergency situation, he'll be evicted. He's there for 50 years. What is your submission?
My lord, this is the third time writ petition, my lord. This is the third time writ petition, third round writ petition. In this petition, my lord, the petitioner, my lord, has challenged.
You do not have any instruction. All impromptu submission from the writ petition. Then the petitioner can make submission. Why will the court wait for a report from you?
My lord, kindly consider, my lord.
Yes, why will the interim relief be granted to you? Please tell me.
My Lord will kindly see the next order, the second writ petition, my Lord, where her ladyship, the Honorable Judge Shompa Shorkar, my Lord, kindly comes to page, my Lord, 65 to 67. Once.
Yes.
I'm troubling your Lordship. I beseech your Lordship to see that order, my Lord.
Yes.
Your Lordship sees, my Lord. At this, may I read it? Or Lordship has already.
Yes.
At this stage, the Assistant Engineer, Ulubedia Highway Subdivision, Public Works, Directorate cannot proceed with the notice against the petitioner. The notice dated July 16, 2024 was issued for removal of encroachment under Section 10(1) of the West Bengal Highways Act 1964. It appears that a civil suit has been filed in respect of the plot of land in question. An ad interim order has been passed directing both the parties to maintain status quo in respect of the nature, character, and position of the B schedule property in title suit number 179 of 2022. The B schedule property has been delineated as a strip of land on the western side of A schedule property measuring about 5 kathas, on which Gadiara Shampur Metal Road exists, as also the left of portion the adjoining east of Gadiara Shampur Metal Road, including lands belonging to the PWD. On a perusal of the application for injunction filed in the suit, it appears that the subject matter in the writ petition pertains to more or less the same area which is the subject matter of the suit. The respondent number 9 filed the suit against the petitioners, restraining them from causing any obstruction or construction on B scheduled property, as the said property connects the petitioner's premises to the main road. The learned civil judge, upon consideration of the prayer for an interim injunction, found that the respondent number 9 had been able to make out a prima facie case, and the balance of convenience and inconvenience would be in favor of granting an order of status quo. The learned civil court recorded the contention of the respondent number 9 that B scheduled property served as a passage for the said respondent to reach his land. As an order of civil court subsists, this court cannot permit the highway authorities to continue to take steps for demolition or removal of the encroachment on the basis of the notice dated July 16, 2024. The said notice will be kept in abeyance. It is true that the PWD authorities have found that the encroachment is on PWD land. The PWD authorities could have taken steps had the suit and the interim order not been pending and the status quo with regard to position has not been granted. The PWD authorities cannot disobey such order even if there is encroachment on the PWD land. Under such circumstances, the respondent number 9 is at liberty to take such steps as he may be advised so that the parallel proceedings may not continue. In the event the suit is withdrawn or any other order is passed by the learned civil judge, a civil court, under the changed circumstances, the Highway Division PWD shall resume jurisdiction over the matter. Till the ad interim order of status quo subsists, neither the state nor any other authority can take steps against the alleged encroachment. Further steps may be taken by the PWD upon intimating the parties and only after the order of status quo is either vacated or varied or modified. Now, my lord, they have taken steps by going to the trial court below. Immediately thereafter, a suit has been filed by me. I have that right, my lord. I have gone before the court below. My lord, injunction application was filed under Order 39, Rule 1 and 2. I will show your lordship, my lord. They have appeared. Cost was imposed.
They means?
This private respondent.
All right.
Because he is the party to the suit. Now, they did not allow that hearing to take place. I have annexed all such documents. My lord, I also have a case so far as my suit is concerned. Because, my lord, admittedly, my lord, they cannot deny, even the state cannot deny that I am in position for 50 years. My lord, I have annexed such documents where, my lord, my ancestors.
Under which provision of law are you occupying this government land?
My lord, admittedly, I say, I will be honest to your lordship. My lord, so far as this question is concerned, my lord, in my respectful submission, my lord, adverse possession. I say that it's an acquired land.
Adverse possession against the state.
Now, my lord, in 50 years, there was never any occasion. What I respectfully submit, my lord, the dispute started with the private respondent. Initially, they filed a writ, my lord, where it appeared that one of the learned advocate of this honorable court had appeared.
No, do not go into all these things. Would you like to shift?
Yes, my lord.
How soon? How soon will you shift?
My lord, only may I pray for one indulgence. Your lordship has seen the order also. My lord, I was not given a chance of hearing. That is also there. That was my second submission with deepest respect.
But it says that notices were served.
Yes, ma'am.
And service return is kept on record.
Those petitioners, they did not get the chance of hearing. If I would have got that opportunity, my lord, I would have appeared and placed my documents.
And in fact, all alleged encroachers remained absent. This is what is recorded.
My lord, these petitioners are there, my lord, where the notices had gone, my lord, with deepest respect. My lord, I'm not.
What are you doing over there?
My lord, all shops.
Shop rooms.
Yes, yes. Someone is using as a repairing of cycles, a tea shop, and it's been continuing.
Yes, now.
If there would have been any scheme of the state government, my lord, I would have.
Well, where would you like to shift and how soon can you shift? What is the private respondent doing? Does he also have a shop?
No, he says his allegations are that he has purchased a property which do not belong to the PWD. Now, their objection is, so far as these encroachers are concerned, that it's creating obstruction, which is not. Which is not. They are having completely separate property. It is only upon instigation. Today, admittedly, my lord, I cannot deny the fact before your lordship, my lord, that it is an acquired land. But the thing is that, my lord, today there is no scheme. The PWD does not even require that place to be, my lord, those encroachers to be removed. No one is disturbing them, only upon instigation of this private respondent number 9.
All right, yes.
May I just submit one?
1 minute.
My lord, may come to page number 105, my lord.
Yes.
My lord, this is the title suit which they have filed, my lord. My lord, may come to the ordering portion, my lord. May I be permitted to read out, my lord?
105. This is the suit of the petitioners.
Yes. My lord, it says that the hearing of the instant application of the ad interim injunction is hereby considered and postponed till their next date. The
Hmm.
plaintiffs are directed to serve a copy of the instant application under Order 39, Rule 1 and 2 CPC, along with the plain and all relevant documents upon the caveator. The defendant is hereby directed to show cause as to why the instant application for ad interim injunction should not be allowed within the next date. But, my lord, I have to say that they have not got any injunction order, my lord. They have said that we have deliberately not come before the trial court and everything, my lord. We have, my lord, they have not got any injunction till date, my lord. This is we have to say, my lord.
Only, my lord, I will.
And moreover, the court has been insisting of the situation, my lord. There has been encroachment, my lord.
I'll beseech your lordship to see the next orders, my lord. I've annexed everything. Kindly see the cost was imposed. My lord, for not, my lord, kindly see the next orders. I've annexed everything. Cost was imposed twice, thrice, okay. They are not. If I do not succeed there, then I do not have any case.
My lord, may I just submit? Page 70 is very much important, my lord. Kindly comes once, page 70.
Yes.
Judgment and order, my lord. Middle portion. May I read, my lord? Now, as the ad interim injunction has been vacated,
That I have
submitted.
submitted.
And so resumes the jurisdiction over the scheduled land. Hence, there is no bar in taking action against the alleged encroachers as per section 10 of the West Bengal Highways Act. So and so. After the said ad interim injunction was vacated by the learned court, the respondent were given opportunity of being heard twice upon issuing due notices by the by the undersigned. But on both occasions they remain absent, from which it may be presumed that they have nothing to represent in their favor. Therefore, considering all the above satisfactions, so and so, my lord, middle portion, just I am not, my lord, in change of the
This order was passed in February.
February.
February. It is time to remove is also long over. Why are you? Have you come on such a delayed point of time?
17 June 2025. The notice memo says, and I have received this on 20th.
28th of February, the order was passed,
Yes.
directing you to remove encroachments within 21 days. So from February, we are in July.
We have received this, my lord. It came to our knowledge on 17th. The memo says, notice kindly takes that at page, my lord, kindly takes that at page 68 once, P6.
It is only because you did not remove within 21 days. That is the reason now they will use police force to remove you. It is as simple as this.
Now, my lord, this came to our knowledge that the order has been passed only on 19th when we received this.
So, my lord,
if we would have been a participant there, we would have placed these documents that a title suit has been filed.
You produce all your records to show that they were heard, they were present.
No, my lord, absent. As per the order, on the occasions twice, the petitioner was absent.
Show that they were served.
Yes.
Please come.
My lord, my lord.
The order passed under section 10 within bracket 3 of the West Bengal Highway Act 1964 is impugned herein. The Highway Act 1984 on 28th February 2025 is impugned herein. It has been submitted that the said order has been passed behind the back of the petitioners, and the petitioners were never put on notice about the proceeding. Stuff. By a communication dated 17th June 2025, the petitioners have been directed to remove all encroachment. Stuff. The petitioners contend that they are in occupation of the subject plot of land for more than 50 years or 40 years.
5 decades.
For more than 5 decades. Stuff. The land may not be required by the government or the PWD immediately. Stuff. It is only at the instigation of the private respondent that the instant proceeding has been initiated. Stop. Violation of principle of natural justice has been pleaded. Stop. Learned advocate representing the state respondents is directed to produce records to show that notice of the proceeding initiated under the Act was issued upon the parties and opportunity of hearing was provided to them. Stop. How soon can you bring it?
Hello?
The documents?
2 weeks, madam.
Acha. Let the documents be placed before this court by way of a report affirmed by an affidavit. Stop. Acha, এটা করুন by 25th. Copy of the same shall be served upon the learned advocate representing the petitioners and the private respondent. Release the matter for further consideration on 6th August. Stop. The 6th August, liberty to mention in the event any coercive step is taken against the petitioners. Liberty to mention
I'm so
upon
grateful.
notice.
My lord, to mention one sentence, my lord.
Liberty
50
to
years.
mention upon notice.
May I be permitted to mention at one sentence, my lord, 50 years, that is posted, active posted. Kindly.
My submissions have been recorded by my lord. Kindly take it.
Yes, next matter.
I'm so grateful. Deeply obliged, my lord.
Thank you. Number 4.
I'm for the petition, Lordship.
Yes.
Lordship, kindly turn page 69, Lordship. The Lordship's order.
Yes. It is in Rupa. This is Rupa Enterprise and this is Shondip
Lordship,
Halkar.
Lordship, in the same hospital, Lordship. In this
Same hospital. Rupa and Shondip has got nothing to do with
No.
each other.
hospital is same.
All right.
No, they have something to do with each other.
They
They're
have,
both represented by my dear friend.
apart from that, not on merits. Yes.
The petitioner relies upon a notification of such and such issued by the Assistant Chief Secretary to the Government of West Bengal Finance Department Audit Branch in support of the submission that for tender value of rupees 1 lakh and above, e-tender through the centralized e-tender portal is mandatory in addition to publication in print media. It has been submitted that the respondent authority has not floated any tender for more than 3 years. By way of stopgap arrangement, some self-help groups are being engaged to supply food materials which is contrary to the aforesaid notification. Fair has been made to direct the respondents to take steps in terms of the said notification dated July 27, 2022. Learned Counsel representing the state submits upon instruction that the authority has taken a decision to float e-tender at the earliest in terms of the notification dated such and such for running in the canteen services. As it appears that the concerned respondent authority in principle has taken a decision to float a fresh tender in terms of the subject notification. Accordingly, the instant writ petition disposed of by directing the appropriate authority to take steps for floating the tender at the earliest. The expression at the earliest shall not be stretched to such an extent so that the petitioner is required to approach the court all over again for the same relief, ability of service and lordship. Lordship, kindly page 68. That was the reason why I moved this petition, lordship. This is a work order issued to such an
So what is your submission that they are not holding tender?
Not only that, lordship, can it just 68 page for once. This is dated 22nd 1 2025. The undersigned is hereby informed and put forth documents of SAG relation to canteen service in the hospital and trial basis for 1 month with effect from 8 to 2025. That is, your lordship passed order 7th February, lordship. Considering this, lordship did not stop them or any interval has been passed. But it was issued for 1 month. And now till date, neither they have floated any tender, but they are going to hand over the same as per our information I have mentioned in the writ petition. From 11 July, they are going to engage another contractor for serving this same thing, lordship.
Another contractor, not extending this contract.
Changing this contractor, 11 July. And lordship, order was 7th February, 5 months has elapsed.
All right.
And the state has stated that they have instruction that they will float a fresh tender. 5 months elapsed, but they are now going to
All right, let me hear.
Lord, may I just give your lordship the timelines, my lord, only to assist your lordship. Lord, after all this, after your lordship's order and all this, my lord, on the 19th of March, lordship, my lord, just 4 dates I didn't tell you, lordship. 19th of March, draft e-tender bid has been, my lord, forwarded, my lord, to the my lord, Health and Family Affairs Department.
All right.
Lord, on
Then-
5th of May 2025, the file was sent back by the to the principal for certain clarifications and corrections. Lord, these corrections and clarifications were made, and on 4th of July 2025, it was forwarded back again to the department for examination and afresh. On 8th of July, finally, Lord, the fresh draft e-tender bid has been approved, has been sent, Lord, back to the principal, as to the Department of Health and Family Welfare. So, Lord, 8th of July 2025, the final fresh draft e-tender bid has been sent, Lord, to the Department of Health and Family Welfare for approval.
That means we are expecting that the
That within the next 6 weeks.
it will be floated.
Yes.
Lordship, can you finalize, Lordship? It will be. Because
Finalize means
Finalize. First step
By the
has to be
department.
taken first, then only finalization
Lordship,
process.
they have given the consent, the authority, so they can float any day in the next week, Lordship,
No,
because
No,
they are
not the
love for
consent.
I'm saying on
They
8th,
have made clarification and they have
that
forwarded.
has
They are
given.
taking steps.
They have received that. They have
Wait
received
till
that.
they are taking steps.
Lordship, can you fix the time, Lordship? Because in earlier occasion, Lordship has specifically mentioned earliest means not to stretch that time. They are stretching that time, Lordship.
Please come.
Lordship, can you fix it? 1 month, 2 months, any day, Lordship.
The
As your
petition
Lordship
is
is there.
aggrieved by the inaction on the part of the respondent. Which respondent? Who is going to float the tender? Hospital.
Principal,
Lord,
Lordship.
that is by the principal of Lord, the college.
Yes, 12.
13, respondent number.
Acha 13, respondent number 13. In not taking any steps to float tender for selection of person to run the canteen services of the hospital. Stuff. Learned Senior Counsel representing the state respondent submits upon instruction that the draft e-tender has already been prepared and forwarded to the competent authority, and the same is, and the draft and the tender notice is in the process of being finalized. Stuff. The tender will be floated possibly within the next 6 weeks. Stuff. Paragraph. The respondent authority is directed to take steps for floating the tender for selection of persons to run the canteen services of the hospital without any further delay. Disposed.
Wait.
Lordship, I am appearing for the petitioners. Lordship, the petitioner is a working professional at the Dubai World Trade Center organization.
Other side?
Lordship, we have served the copies.
Where?
Affidavit of service. We have served the copies on Monday, Your Lordship.
I'm praying for short pass. So Mr. Nilanjan Bhattacharya leading me, my lord. The start we have received a copy. I have already sent it to the department for instruction.
Department.
My lord, the passport authority, my lord.
All right.
My lord, short. I pray short pass hoga, my lord.
Short pass over. All right. Come back. Yes.
My lord, I am for the petitioner, my lord. But this is an assigned matter, my lord. This is with regard to, my lord, Emma distributorship, my lord.
I am for the state.
Yes. This is a hearing matter.
Hearing matter. My lord, similar order has been passed by the coordinate bench, my lord, in a similar matter, my lord.
Are you aware of this order?
No,
Yes, my lord, we are aware.
I am not aware. Others may be aware. A copy they madam. Should give me a copy.
All right, take down the number WPA 9680 of 2022. 10th December 2024. Why are you mentioning after such a long period of time? In December it was disposed of or what? Disposed.
This is a similar matter, my lord.
It's disposed.
Yes, my lord. This matter has been disposed of, my lord.
Right.
And my lord, right now, my lord, I'm
Any appeal preferred from this
no,
order?
my lord. Right.
As on date, no.
As on date, no appeal.
Right.
I consider this and come back, my lord.
Yes, yes.
The issue involved whether my learned friend falls within the definition.
Consider it and come
I
back.
will.
My lord, your lordship can pass a similar direction, my lord, because my lord,
Without noticing what is there.
my lord, I'm placing the writ petition, my lord, if your lordship
It is a
decides.
matter of 22. It is coming for the list after such a long
And
period
I
of
have
time
mentioned
for
the
hearing.
matter, and my juniors also mentioned the matters, my lord, but it did not appear in the list, my lord.
Yes.
So, that,
so you have to give court the time. It cannot be somebody has passed an order and this court is just going to copy and paste. It has to be heard.
Yes, my lord.
Yes, it will be. It
So
will appear for hearing.
let it remain its position, my lord.
You want the matter to be heard. Whether it will be in which position the court will decide, it will be taken up for hearing. এটা অ্যাসাইন ম্যাটার আমাদের কোর্টে এতদিন ধরে পড়ে রয়েছে আপনি
My lord, I am appealing for the petitioner, my lord. My lord, the petitioner before your
Who is your other side? You
not
are
to buy back the my lord, respondent bank lordship only for the bank.
yes.
Petitioner before your lordship, my lord, is the borrower, my lord, who placed a OTS proposal before the bank authority. It was, my lord, accepted. My lord, as per the OTS proposal, the petitioner deposited 8 lakhs upfront. My lord, subsequently, he was pursuing the matter, my lord, with regular follow-up. He was issuing letters, my lord, and in the meantime, my lord, due to paucity of time, he asked for some more time to pay the money. But after a long chain of communication, my lord, only in the year 24 at around March, my lord, he have been intimated that the bank authority has cancelled the OTS proposal on November 2022, my lord. My lord, that letter has never been supplied to the petitioner before that communication letter, my lord. If your lordship will find it at page 15, my lord, P3 on 26/3/2024, bank by this letter, my lord, intimated that the
Page 16?
15, my lord, 16. 15 is the date when it is on 26th of March 2024.
Yes.
When bank finally spoke, my lord, and told us that they have cancelled it. My lord, with this letter, they hand up, my lord, if your lordship kindly turn up the next page, my lord. This letter dated 10 November of 2022, my lord. My lord, this letter was never been supplied to the petitioner, my lord. No communication were made. Petitioner is willing to, my lord, honor the OTS proposal which has been accepted by the bank.
No, they do not accept it.
My lord, that is later on, my lord. In fact, my lord, they have on several occasions the petitioner has approached the bank. Bank only after 2 years, my lord, or almost 2.5 years, my lord.
Show the acceptance.
My lord, at page number 12, my lord, annexure P1.
Yes.
This is the OTS proposal, my lord. OTS proposal, may I read it for your lordship?
No, it's 53 lakh 25.
53 lakh.
53.25.
Yes, my lord.
Upfront amount of 8 lakh already deposited. No need to be approved. Remaining amount 45 shall be deposited within 3 months. Beyond such and such. Charge posted a check, such and such, consent decree. All right. Now,
thereafter, my lord, on several occasions, the petitioner before your lordship visited the bank.
Show the payment of upfront.
My lord, upfront, my lord, they have already accepted, my lord, in their. My lord, I have annexed my letter, my lord, where
Page 12 is of March 2022.
March 22, my lord.
Right?
My lord.
Now you had to deposit everything
My lord.
within 3 months from
My
the
lord.
date of conveying.
My lord.
So everything should have happened within March, April, May, June 22.
My lord.
All documents.
My lord, what happened? In the meantime, petitioner visited the bank. He told the bank that he is facing some financial problem. Let that be extended. Verbally, the bank has accepted it and allowed him to.
That is your submission.
That is my
Verbally
submission.
accepted.
My
The
lord.
bank will say the bank has not accepted.
My lord, let them file an affidavit, my lord. Let them counter
What
my.
is the position of the
Lordship,
secured
may I
asset?
submit? May I
Yes.
submit? Lordship, admittedly, the account has been declared NPA.
Right.
That is in their pleadings,
Hmm.
and there is no dispute about their financial facilities they avail from the bank, Lordship. Kindly note, point out the Lordship. Kindly see the dates. That's very important, Lordship. That 31st March 2022, Lordship rightly pointed that it should be done within 3 months. Next 3 months, they have not done it. They've deposited the upfront amount that is there in the settlement letter, Lordship. But now, what my learned friend is submitting, that they regularly communicated with the bank. There is no proof of that, Lordship. No, nothing. They have written
What is
first
the
time.
position of the secured asset?
That is their, Lordship. We have not taken any further steps. That we will take
Are
according.
you still any surface proceeding initiated?
That's pending, Lordship. That we are in the process, Lordship.
When will you pay?
My lord.
Lordship, they are not agreed by those 30. They are not. If they are agreed by the any action taken under the Surface Act, they could have referred before the DRT, Lordship. That is not there.
When will
It's a
you
Lordship.
pay?
They are actually trying to bypass the system, Lordship. May kindly consider.
When will you pay?
Within 3 months, the entire remaining residue. My lord,
Lordship,
my lord, residue along with interest, my lord, I am willing to pay from the date
You
of.
are willing to pay from March 22. We are in July 25.
My lord, in what has happened, if I may rephrase, my lord. My lord, in the meantime, we were in daily communication with the bank, my lord. My lord, it is only on the March of 2024 we have been communicated by the bank that while we were in touch with the bank authority, my lord, they have cancelled. They have not.
Obviously, they have cancelled it.
Lordship,
lord, they have not
kindly
intimated,
sees
my
the
lord.
annexure
They have
P4.
handed up.
Please come.
Settlement proposal they are enforcing before a
one-time settlement of the loan account. Stop. Learned advocate representing the bank is directed to place before this court the up-to-date figure which the petitioner is liable to pay in case one-time settlement is allowed. Stop. When will you come up with the figures?
Lordship, may kindly allow for 1 week. One week time, Lordship.
1 week. Next Thursday. List on.
My lord, may it be on Wednesday, my lord? Thursday.
Yes. 16th. 16th. 16 তারিখ.
My lord, may I file the affidavit of service?
Yes, please.
My lord, item number 6, my lord, only the date has not been fixed, my lord.
It will appear for hearing. I'll speak to my officers when the assigned matters can be given in the list.
Item number 8. Will I beg to appear on behalf of the respondent?
I'm for the
respondent. State.
A very limited.
Not a party.
State is not a party.
Not a party.
It is not a party.
I have been entrusted with you in the same very limited submission.
For whom have you been entrusted?
I have been
State is no. Are you there in this matter? Check up.
Deputy Superintendent DIB Kishannagar PD.
With regard to some investigation,
Yes,
maybe.
this is, I just tell you, Lordship, just inquiry
part for the OCI cardholder.
Yes.
This is
Well,
I
that
am.
is a
This
part
is my part. Now
internally,
let him
right?
sub.
Internally.
This much on.
First, I have to cross the first hurdle.
Yes, please.
With regard to the maintainability part as raised by the Honorable Court.
Maneka Gandhi.
Maneka Gandhi.
Maneka Gandhi.
Maneka Gandhi.
Maneka Gandhi is something
no.
different.
No, that is different.
Yes. Kindly takes paragraph 13. 1991 3 Supreme Court cases 554.
Yes.
Louis read it.
Claim of Indian citizenship by foreigner.
Is 30.
Domicile. All right. Which
Paragraph 13.
13.
Third line. Or fundamental right of the foreigner is confined to Article 21 for life and liberty and does not include the right to reside in the country. This is, may I show to your lordship the gradual progression or the gradual development of the this issue before the Supreme Court. This is in 1991. Then your lordship kindly takes 1994. 1994 Supplementary 1 Supreme Court cases 615. Page 31, paragraph 31 and 35. Here also, Louis read it has been referred. My lord, the court has your lordship got 31.
Yes. Yes, yes.
31. A small paragraph. This court took a view that the fundamental rights are available to foreigners as well.
Only article including
yes, Article
21. It is maintained.
Paragraph 35. It is true that this court in Louis did it took the view that even a foreigner has a fundamental right, but the fundamental right that has been discussed. Next, may I take your lordship? I should not be considered troubling your lordship on this. This is 1996 1 Supreme Court cases
742.
742 National Human Rights Commission.
Right.
Paragraph 15.
This is I think this is also kind of settled law.
Yes, settled. It is settled. We are unable to accept the contention that the first respondent has no threat exists to the life and liberty of the Chamkas. These are the sort of refugees guaranteed under Article 21. Kindly take 16, where again Louis read it has been referred. Then kindly takes, my lord, 17 towards the bottom.
Yes.
6-7 lines from the bottom. It says. It says that the prescribed authority may, on receipt of an application, register a person who is not a citizen of India. So this application was by a non-citizen.
Obviously, otherwise who will come for an OCI?
Yes, this has been considered, and the collector whose jurisdiction applicant is ordinarily resident. Here the case of this petitioner is she has become a resident by virtue of marriage to an Indian. So she has claimed the status. My lord, again, my lord kindly takes paragraph 20 in this.
Yes.
We are a country governed by the rule of law. Our constitution confers certain rights on every human being, certain other rights on citizens. Every person entitled to equality before the law and equal protection. So also no person can be deprived of his life and personal liberty according to the procedure. Thus, state is bound to protect life and liberty of every human being, be he a citizen or otherwise. This is in my humble submission where I come in as that my rights where I had preferred an application. I only beseech this honorable court to intervene to the extent that whether my application was at all considered or not, that I have a right to know.
Now, if it is considered and allowed, is one thing.
Yes, and
if it is rejected, you again come.
Yes, I agree.
Then you say that this is my right.
Yes. That is where I come in. My first application, I was given domicile visa status. I continued here for several years. I married. Thereafter, my first application in 2021 is placed but is dropped without any reason. Again in 2022, I file. It is still showing under process. Here
22,
23.
23.
23.
Hmm.
It is still under process. But here my
Is
cause
there
of
any time limit mentioned within which an application is to be processed?
I did not find. And here I come in. I only beseech your lordship to intervene to the limited extent that I may be given the knowledge of, if at all rejected, under what grounds, or whether at all rejected or not.
So you found it last till 1996. Thereafter, you didn't find
There are,
anything.
but these only these are being repeated over and over again. Even 2000. But I do not think that the point of maintainability will be an issue on this.
আমি বললে হয়তো হবে কিন্তু কিছু বলছি না
What is your submission?
My lord, I didn't find anything against that, my lord. I leave it to your lordship, my lord. I have only factual aspect, that is, I have got the
What is it?
My lord, the ex-wife of the husband of the petitioner.
Ex-wife
Ex-wife
of the husband of the petitioner. All right.
has filed.
Both the husband and the ex-wife and these present petitioners were initially foreign nationals.
I didn't get it. The petitioner,
But
the
the petitioner
husband was also foreign.
yes, was
Oh, he is not an Indian citizen.
not an Indian by birth.
See in India then.
Well, ISKCON devotee.
He is?
ISKCON devotee. All are ISKCON devotees.
First marriage dissolved by way of a order of the foreign court's order.
Yes.
Now he came back in India and fall in love to another person who is
he
residing in
continues.
ISKCON.
But he continues. He has a company.
Huh.
He has a business. He has been here for the last 20 years.
Under which provision of law?
He is a citizen of India.
He has obtained
He has obtained.
citizenship.
He is a citizen of India. His wife, ex-wife, also is a citizen of India, but were married in Ukraine.
All right.
Their marriage got dissolved in Ukraine.
All right.
Now, after dissolution of the marriage, he has remarried to this lady, the petitioner. My lord, then my learned friend come in.
My instruction came that the ex-wife of the husband of the petitioner has filed a case against the petitioner and the husband that the divorce filed was fraudulently, and for declaration that the divorce is false, and the case is still pending.
In Ukraine?
No, here in family court and
You
Mathura.
obtain a dissolution order in Ukraine and you challenge it in India?
But
By mutual consent.
Family court.
no, I don't.
By mutual.
How is it possible?
Oh, well, না না সেটা তো হচ্ছে petitioner. সেটা petitioner. ওদের অভিযোগ সেটা নয়। ওদের অভিযোগ
This is what I received from.
No, you
but I have
check
to
up.
get, yes, I have to get the.
Where was the dissolution of marriage? Where did it take place?
That investigation is
In
going-
Ukraine.
Yes.
And you challenge it in India?
Yes.
My lord, and the
I
case
don't
is still
know.
pending as per the instruction, my lord.
Where is
I have
it
asked
pending?
for, my lord,
Navadvip.
reports,
Navadvip.
In Navadvip.
and the case is pending in additional family court Mathura. That's.
Oh,
what
acha,
is it
sorry.
called?
Mathura.
Decision, my lord.
Mathura.
In India.
In
India.
Mathura.
And that case is still pending according to the report, my lord. But
But the divorce still
is-
surface. There is no interim order.
Now suppose I do not know if the order is recalled. What happens? The lady stays here as a wife of such and such whose marriage is held to be valid. Then what
But
happens?
I am not asking for a citizenship here.
OCI you want
Yes, only a resident visa status.
on the ground that you are the wife of such and such.
Yes, my lord, but just because of a pendency of marriage without any interim order, my lord, I am not going into the merit of that, but I may have a right to know at least so that I can counter that. At this stage of this writ petition, I am not even aware of their reasons.
Thing is whether I'll permit you to enter into this zone or not.
The question is that whether the OCI is coming under the zone of the fundamental right.
That was the first question posed by the court.
I have seen this.
এই, তুমি বলছো কেন?
বলবো না?
তুমি এখানে party নয়, তুমি কেন
No,
বলছো?
I just
No, because this was the question which was posed to the petitioner. How is the writ petition maintainable at the instance
Correct.
of a
Lordship is
foreigner?
absolutely correct. Now, if in my humble understanding,
Not understanding there are judgments, please bring.
No, Bondhuva Mukti Morcha and the others which my learned friend has relied upon. This is
Yes.
simply because of the fundamental right and the protection of the life.
Only Article 21
Only
is the
Article
only
20,
place where you
21.
can enter.
Only Article 21, where it says protection of the life and personal liberty. No person shall be deprived of his life or
No,
personal.
that is all right. That
That's
is all right.
Now the question is that whether the OCI card, application of the OCI card is coming under the zone of the fundamental right of the person.
There are judgments against you.
I know that judgment.
And
And my favor as well.
Yes.
But even if for argument's sake, if I consider what my learned senior friend says, my lord, a person applies under a law of India. His or her application is not attended. What remedy does he have? May I?
He doesn't have any remedy as such. You go and apply somewhere else. Let me see how much remedy they'll provide you. They'll just throw you out, pick you, and throw you out.
That's the other side of the coin.
That is always available to the sovereign nation. That is always available.
Then
They can throw me out, but I have preferred an application or under a recognized statutory provision.
this statute is not applicable to you.
But the statute provides me, confers me with the right to apply.
You file it on record what you have to say.
Yes.
I'll keep it on record so that he also gets to know.
Lordship.
And then if a decision is to be taken as to whether the writ is maintainable or not, then it will be seen. Please come.
By way of an affidavit, if possible.
That is why it's on
we
hold.
can have a.
It is not disposed of, it is on hold because the pending.
How long will you keep it on hold?
The case is
They can-
pending, my lord, unless
they
the
can
case is
reject it.
disposed of.
Now the case remains pending over in India
That's
for years together.
Ultimately, it has to be dismissed.
Take a decision and then communicate so that he has a different
Get a
course
second
of
chance to
action.
come back. Get a second chance to come back.
No, at least I have an option.
Different course
Correct.
Lord, I have an option to approach the Mathura court for disposal of.
wherever he can take steps.
He's a party there.
আরে তোমরা বলো যে এইটার জন্য আটকাচ্ছে তাহলে আমি ব্যবস্থা করব।
হ্যাঁ আমি তো সেটাই বলছি।
যাবো একবার মথুরা।
For dissolution of marriage, a third person is made a party. I do not know.
Well,
I do not know what is happening.
It can be explained in a one word that is called farrago.
I know what is that, but I cannot say.
So I হয়
Learned advocate
মায়াপুরে কমন
appearing on behalf of the Union of India submits upon instruction that the application filed by the petitioner for obtaining the OCI card is yet to be disposed of. Stop. Let a report by way of affidavit be filed by the concerned officer of the Union of India. How soon?
4 weeks, my lord.
4 weeks.
I have to take, my lord, this family court, at least,
Do one thing. You have to reason it out first as to how the marriage which stood dissolved in Ukraine.
my lord, that is my lord, court jurisdiction, I cannot.
No, just check up. Check up whether it is proper or not. You just
That's why it's filing, my lord, Mathura. One person has to give that, at least the record from the Mathura or the searching report. That will take
In
some
my
time.
report also,
the parties and everything you have to
in my report also this has been, there is a whisper, the questionable marks is
whatever. কি বললাম? Within 4 weeks. Within 4 weeks একটা ডেট দিয়ে দিন তো আজকে 10 তারিখ তো 1 2 3 4 8th of August.
And at least one line.
Released on 20th. Exception to the report may be filed prior to the adjourned date. Yes, one line.
One line regarding I have attempted to enter into the maintainability aspect.
Get pillars.
Much obliged.
Number 9.
Well, at 9, I am for the petitioner.
Yes.
Well, at that matter with regard to, my lord, the public prosecutor and, my lord, his daughter
Also, the
being
added
there in the
respondent,
same
late Mr.
litigation.
Bhattacharya.
Lord, your lordship will kindly recollect, my lord, on the last occasion when your lordship took up the matter, Mr. Bhattacharya raised an issue with regard to suppression of a particular order being passed in the trial court.
Yes.
Lord, if that order is with your lordship's
Yes,
lord,
it
a
is.
part of the records, it's an order of 4th of April 2025. Now, my lord, kindly see the second paragraph of that order which records. My lord, has that order, my lord?
Yes, yes.
Kindly see, it records today is fixed for hearing petition dated 26th of March 2025 filed by the accused persons. My lord, this entire order is passed on the basis of this petition. My lord, I've taken out the certified copy. Kindly have a look at this petition. Kindly see the nature of this petition. My lord, in this petition, my lord, subject to correction by your lordship, firstly, my lord, there was no prayer made to change the learned public prosecutor. On the contrary, my lord, what was sought to be put on record is the conduct of the learned public prosecutor, particularly with regard to what is said in paragraph 3, that a 161 statement was changed during the course of trial, and that was brought to the notice of the court, the trial court. Now, my lord, the reason why, my lord, I have taken instructions, my lord, as a now officer of your lordship's court, I would say, my lord, that this order should have been disclosed. But, my lord, kindly see and kindly visualize whether the learned trial judge, firstly, my lord, no prayer was made for the learned change of the learned public prosecutor. Secondly, my lord, the learned trial judge doesn't even have any power to change the learned public prosecutor. My lord, just to give an example, my lord, on a lighter note, my lord, if I take out a 226 petition before a district judge and the district judge says, sorry, I have no power, so rejected, do I need to challenge that order of the district judge before this honorable court, my lord? I'm asking myself. So, my lord, this, and if your lordship sees this order, everything is recorded, including the fact that the learned public prosecutor and the counsel for the de facto complainant who was representing up till a particular stage, everything is admitted, my lord, in the last paragraph of the first page of the order of 4th of April. But, my lord, this order, my lord, subject to correction by your lordship, we cannot, there is nothing wrong with this order to the extent that firstly, there was no prayer for change of public prosecutor, which is my specific prayer before this honorable court. And it is your lordship who is only entitled to do that. The sessions judge could not have done that, and hence I could not have revised that order.
Listen, if A appears or B appears, it hardly matters to you. But he is alleging that he is not facing a proper trial.
My lord,
And this order
certainly
also
matters to
discloses
me
that.
because
Why?
after all 13 witnesses have already adduced evidence at the
Whatever
stage
is
of
there is
trial.
there.
And my lord, the
What
learned
is going
public
back?
prosecutor.
My lord, one more thing I wanted to tell your lordships, my lord. If I had such an intent of suppressing and things like that, my lord, on day one when he applied for addition of party, I didn't oppose it. Otherwise, I would have opposed him tooth and nail, my lord.
Well,
It's
it
all
is
right.
specifically,
Thing is-
lordship sees the learned judge specifically records the wakalatnama filed on behalf of the de facto complainant during the investigation stage. Now, my lord, she had filed her wakalatnama in investigation stage. Thereafter, before the trial court, that is the sessions court, a fresh wakalatnama was filed on behalf of fresh set of advocates. That is also there on record.
Is
We were not.
Tapon and Sunita no longer there?
No, she had filed
Tapon is
her.
there.
My lord, she had.
Yes.
Sunita had filed her
Tapon is
wakalatnama
there.
at the investigation stage on behalf of the de facto complainant in the before the court of the learned magistrate. And before the sessions court, after it was committed, my lord, Mr. A.H. Bishas and Aurobindo Mitra had filed a fresh wakalatnama, which is also on record, and this is way back on 25th August 2020. My lord, this is the wakalatnama
I do
certified.
not wish to, my lord, kindly considers this, my lord. I do not wish to make comments
from the
with
trial
regard
court
to, my lord,
records.
discretions of learned advocates in their professional capacities, my lord.
I do not understand if there is a request for change. How is it troubling you? And why is
a
it
de facto-
troubling you?
Well, certainly, because my son was brutally murdered. But
Hmm.
it was a case of contract killing by the petitioner.
Not praying
I
for
am
discharge.
the victim's father. Right from the very outset of this case, Mr. Chakraborty, the learned senior public prosecutor, had been dealing with the case. 13 witnesses examined the complaint. He is absolutely conversant all along with the case. This issue of change of public prosecutor could have been raised immediately at the time of framing of charge, or in
No,
2020 when Mr. Chakraborty was appointed.
Yes, that was because the daughter and the father.
No, my lord, Mr. Chakraborty, learned special public prosecutor, was appointed in 2020. His daughter was appearing for the de facto complainant in 2019. From 2020, a fresh set of advocates is appearing on behalf of the de facto complainant. This is the certified copy of the wakalatnama.
Page 28 of my application.
All right, you tell me one thing.
Lordships.
The de facto complainant,
Lordships.
right, and the PP, they lie on the same plane.
Subject
One
subject
supporting
to
the other.
Milord, subject to correction by your lordship, Milord. The law is settled by the Honorable Supreme Court. I have brought those judgments. Milord, the Supreme Court clearly says
The state has
that
to
the
be
office of
neutral.
the public prosecutor stands on a completely different
Neutral
pedestal.
footing.
The reason is, Milord,
Yes.
the reason is Mr. Dev's client allegedly is the victim, rightly or wrongly. Mr. Dev's client has lost someone and he is alleging that to me. So Mr. Dev's client and his legal team, their single point objective would be, and maybe rightly so, that I am convicted. The public prosecutor's role is not to secure a conviction. The public prosecutor has to be dispassionate. The public prosecutor has to only uphold the interests of justice.
A neutral person.
Absolutely.
I believe
So the learned public prosecutor,
the neutrality of the person.
the learned public prosecutor, আমি কোর্টের একটা query respond করছি. Well, therefore, my lord, the law requires.
Where is the state?
And the Honorable Supreme Court says.
Lordship, I'm led by Mr. Tapan Kumar Mukherjee. He's on legs in court number 4.
Mr. Mukherjee's stance was that if the court desires, he can take
Yes.
steps with the LR and the
Right.
PM.
Where is it?
Lordship,
You have written instructions.
Lordship, on the last occasion,
someone from the
he has
panel can be
submitted the report, Lordship.
Did
The
you?
instruction. Yes, Lordship, 15th May 2025.
I don't see anything on record. 15th of May.
Yes, Lordship.
Yes, photocopy. Photocopy of the prayer of the accused. This one page, 15th of May.
Lordship, Lordship.
No, it is not that.
It is just a reference to the.
Yes, nothing is mentioned over here.
And my lord, indeed,
such flimsy allegations which
my lord,
doesn't have
indeed,
any
the
sort
learned
of
trial
support.
court has recorded that there, for a same witness, there are two 161. One different copy of the same witness has been supplied to us in terms of 207. When we go to cross-examine, the public prosecutor confronts that witness with another set of 161. Everything comes out in the order sheets, my lord. I do not want to open, my lord, that Pandora's box. Because it relates to, my lord, learned advocates.
No, these are allegations which have never been substantiated.
I have taken those
Listen,
points.
will it be very fair if these type of allegations are to be substantiated against a professional who is your fellow colleague?
Absolutely.
It will not be nice.
He is a senior prosecutor in the Alibag.
Whoever it is. Whoever.
I do not think my learned friend is referring any of this.
Speaking for myself, my lord,
against the learned public.
Lord, speaking for myself, my lord, if I was in the shoes of that.
Get somebody who is no way connected with the de facto. Be engaged. It is as
my lord, since 2019, the public prosecutor was appointed in 2020.
Tell me one thing. As counsel brief, you get briefs at the hearing stage. It is not necessary at the motion stage you will be briefed. If somebody else comes in, all documents will be there.
My lord,
where is
I bow down before your lordship, but in this case, the de facto complainant was appearing in 2019.
Yes.
She resigned from the brief in 2019 and a new set of advocates representing the de facto complaint appeared in 2020.
But then, there should not be any hunch in the mind of the accused person that he has not been provided with a fair opportunity of trial.
I think
nobody
is disputing the neutrality of the public prosecutor.
He is.
But then let the legal remembrance take a call.
Yes. This is what his prayer is. He doesn't want anything more. And the court is not appointing anybody.
Let the legal remembrance decide the issue neutrally. Well, I believe
that after all the entire exercise, let the legal remembrance decide whom to appoint. Whether to also
instead of
remove the
current
current
public
incumbent public
But
prosecutor.
submission made on behalf of all the parties. What is your name?
Lordship, my name is Mona Lisa Maiti.
Where is the recorded on record of the state?
Lordship, both are engaged in court number 4 and 18.
Then none of the names will be recorded. Mind it.
Lordship.
আচ্ছা কি বললাম made on behalf of parties stuff. The petitioner has submitted that the public prosecutor who is handling the
Trial, sessions trial.
case pending before the learned additional sessions judge, 10th court, Alipur, in ST number 01 within bracket 11 22 11 টাই শুধু ব্র্যাকেটে আছে space R number 61 of 2020 is acting more on the behalf of the de facto complainant. Stop. The petitioner submits that the public prosecutor should take a neutral stand and not take side of the de facto complainant. Stop. Initially, the de facto complainant was represented by the daughter of the public prosecutor. Stop. Prayer has been made to change the public prosecutor. Stop. The prayer of the petitioner is opposed by the learned advocate representing the applicant / de facto complainant. Stop. Next. As all is entitled to a fair trial, none should reel under the misconception that a proper trial was not allowed to a litigant. Stop. Only for upholding the interest of the trial and for maintaining its sanctity, the court is of the opinion that the legal remembrancer should take a call with the request of the petitioner for change of the public prosecutor. Stop. The legal remembrancer is directed to engage any other public prosecutor or special public prosecutor to handle the case from the list of the public prosecutors / public prosecutors maintained by the state of West Bengal. Decision shall be taken by the by the legal remembrancer at the earliest, but positively within a period of 2 weeks from the date of communication of this order. Writ petition.
Lordship, I am for the state, Lordship.
Take this. What is the use after coming out when the order is disposed?
Lordship, I was engaged in part 4, Lordship.
Yes, call the next matter. Take back the certified copy.
My application.
Yes.
I am for the respondent. On the last question,
Which respondent? Which respondent?
All respondent.
All Union of India?
Yes. May I submit the instruction, madam?
Yes,
From the authority.
What is the matter?
Well, there was a purchase order that was issued. It had to be done. Supply was to be effected within 2 years and there's certain delivery period.
All right.
Each consignee railway under the main purchase order issuer could decide on their own respective delivery schedules. But this had to be done within a certain period of time and each schedule is otherwise mentioned. For the first 8 months out of 2 years, they give me nothing, just make me sit idle. In the next 12 months or about 10 months, they impose an orders of the entire quantity. So naturally there's a delay because the delivery schedule says it has to be within a period of 2 years, and first, second, third different tranches are identified. Within the tranches, each consignee railway can have their own. First 8 months they don't do it, so first 2 schedules go. When it comes to 1.5 and second, they impose the entire lock, stock and barrel all orders. So the moment there is a delay, they started imposing liquidated damages. Well, liquidated damages have been imposed under the contract, which is a sale. My injunction that I need, because your lordships have now held from Kailashnath to judgments of this honorable court, that unless you have suffered a loss, you can't impose liquidated damages. And liquidated damages, if it's held contrary to the contract, is arbitrary under Article 14. My only prayer for the injunction that your lordship has granted in the last order, my lord, because he was to take instruction that this liquidated damages will not be imposed except in accordance with law.
But why will the writ petition be entertained? You have a suit forum. Civil court forum is there. Why in writ?
I'll tell you, lordship.
Kindly see last
My lord,
instruction, last page of the instruction, my lord.
Kindly have a look
Kindly,
at
my
the
lord.
prayers in the writ petition.
Last page, my lord.
There is a contractual obligation by and between the parties.
Yes.
Go. You.
Last
If
page.
there
You should
is
kindly see the last page, my lord.
if there is
Last
anything.
page. Arbitration clause
contrary
is
to the
there, my lord.
Arbitration clause is not a bar that
Arbitration is there.
Yes, my lord.
that your lordship.
Arbitration clause, they are Western Railway, my lord. This is, my lord, Mumbai High Court jurisdiction, my lord. This is Calcutta, my lord.
Is not a bar that I'll be able to show judgments.
Kindly see my instruction, my lord.
The writ court is not going to entertain this type of press.
Decisions, my lord. Lordship will just bear with me for 2
Not
things.
the decision. Show me the contract.
Yes, my lord, I will show them. First, may I just indicate what my prayers are to show why the writ is maintainable? It's 34. My lord, page 34 is my writ. Prayers. My lord, page 34, prayer B, the modification advice, that is a sale. And for granting of extension of time, and also for deduction of liquidated damages. Now, my lord, my specific case is naturally that this is arbitrary. This is DHO's Article 14. This is, my lord, I'll make that distinction which is available to me in law, and I'll back it up with judgment. My lord, here I am saying that recourse to the disputes pertaining to the contract are probably arbitrable. Apart from the fact that your lordships have held that arbitration is not a bar to 226, here I am saying that imposition in terms of the contract itself is arbitrary. So I am on a facet of Article 14 that although the contract allows you to, you can't impose because you're a statutory authority and you have to parallelly.
Yes.
That even if, because you're a statutory authority and you're a state under Article 12, even if the contract permits, you can't do what is contrary to law. If you're doing something what is contrary to law, it's hit by Article 14 and therefore it is maintainable. Well, in 2 points, I'll back this up with judgments, Lord, instead of speaking English here. First is an arbitration clause is not a bar to an Article 226. The second is even if the contract permits liquidated damages, imposition can be made only if there is a loss. Well, if I may just try and make this.
Show me the contract, please, pursuant to which all this is happening.
Yes, Lord.
Acceptance letter is at page 98.
No, delivery schedule down to
But procedural starts on page 101.
Well, kindly have a look at page 101.
Page 40, I can see an e-tender notice.
Yes,
Where
no,
is the
101, I
contract?
wanted to show just the
101.
timeline, my lord, once.
Where is the contract?
You should kindly come to page 75, my lord. Oh,
That is the tender that your lordship is looking at.
Contact.
Yes, where is the contract?
98.
98, if your lordship looks at,
75, my lord.
All right, I'm coming. You please wait. Do not jump in between submissions. 98 is the acceptance letter, advance acceptance letter.
That is the advance acceptance letter.
Yes.
And this has all the terms and conditions. And if you look at, if your lordship looks at page 101, this is the first purchase order. Please have a look at serial number 3. Delivery schedule as per clause 22. Sorry, not page 100.
Yes.
Delivery schedule as per clause 22 of instructions to tenders and general conditions of tender for supply of contract at page number 29, 30 and 58 of tender document. This, if your lordship now just takes up by page 68.
Which page?
68.
All right.
This is what is referred to here, my lord, 22.
Yes.
22.1. I'll just highlight the arbitrariness here. Delivery period of the contract for the tender is 2 years from the date of issue.
I will not go into this.
No,
I will simply not go into this.
I am not inviting
You-
lordship to look at anything else. Except for 5 minutes, I just highlight why it's arbitrary and why LD can't be imposed. Well, there is
Assuming there is arbitrariness on the part of the authority, why will the writ court entertain you?
Mother Ali.
Why will you not go before any other forum as per the contract or as per the regular civil laws?
If I may just answer that query. Well, now your lordships have held that if an arbitrary action is there, then an arbitration clause is not a bar for an Article 226 action. I wanted to highlight the arbitrariness here, and I'll be able to first justify.
I am not going into arbitration. You have the regular civil law. If you say arbitration is not maintainable, go before the civil court. The court is not relegating you to the arbitration.
So that they'll come and say they'll file section 5 and 8 saying there's
That's
an
up.
arbitration clause.
It's for them.
That's one bit of it. No, if so his point is that there's an arbitration agreement.
It is not his point. The court's point is why
as to
will
why
a
your
writ
lordship
court
will interfere under
Yes.
on two facets. One is if we can show that this imposition is contrary to law and therefore arbitrary. First. Second, because of the MP Sugar Mills MP Power judgment of the Supreme Court, that even in matters of contract, two aspects are involved. One is the aspect of estoppel, promissory estoppel, and the doctrine of legitimate expectation. And even in the commercial realms, Article 14 will have to be complied with, even if I come for a money claim now.
Yes, for a money claim. This is not a money claim. Money claim, even I have held that it is maintainable. But then here, no.
Please have money, which is why I'm aware of your lordship's decision.
My jurisdiction point also, my lord,
Kindly
negative.
have a look at not my prayer once. Kindly have a look at prayer D.
Yes.
A writ of in the nature of mandamus commanding the respondent number 2 to forthwith refund the entire amount of 55,958 which has been illegally deducted pertaining to purchase and supply order dated 11 September 2023. Kindly turns over Milord F, also a money issue.
No, no, sorry. This is a circuitous way.
You lordship kindly come to my lord, page 75, my lord. Only my lord, only 1.1, page 75, my lord.
Just to get over
Para 37, my lord.
1 minute, please. Yes, show the decisions that you are relying.
My lord, one territorial jurisdiction कौन क्यों तोले नहीं Supreme Court judgment लो दाओ. My lord, kindly have a look at this one decision, my lord, where arbitration clause is not a bar if there has been arbitrariness.
No, I am not going to the arbitration also.
My lord, no, my lord, the issue will probably be the same. I'll just highlight this, my lord. Once your lordship copy now. My lord, this is 9 June 2022. Lord, I'll just tell you, lordship, why I'm citing this because it refers to a host of Supreme Court decisions. I'm just
Arbitration.
Page 2, it appears from the documents on record that the railways issued by the termination notice and so with a copy of the bank for invoking the bank guarantee furnished by the petitioner. The termination notice was served on the petitioner and so. Significantly, on the same day of termination, 9th May, Railway issued a revised chart for completing the work which the petitioner was due to undertake. Here, the modification advice under challenge in this writ petition. The documents also on record further show the railways by its very act have waived earlier notice and notice was treated under clause 62 of the general conditions of contract. The railways was thus under an obligation to issue a fresh notice under clause 62 before terminating the contract, really for enforcement of a clause in the GCC. The defense taken by the railways of an arbitration clause in a standard condition of contract is not tenable in view of the decision of the Supreme Court in Harbanslal Sania versus Indian Oil Corporation 2003 to SCC 107, affirmed by the Supreme Court in the Tantia construction, most oft-cited, 2011 5 SC 697, and 1998, this is the Whirlpool relied on. View of the decision, the impugned notices issued by the railways cannot be sustained, allowed, and direction set aside. If your lordship desires, I can show these judgments.
No, please.
Where it Just to multiply, I don't show it because it's clear that if there is arbitrariness, then I am not precluded from approaching this honorable court. But also, kindly recalls 88 Supreme Court where suit has found to be not an alternative remedy. But here I'm invoking a separate right that is flowing from Article 14. And one aspect, if I may just show, LD impose করতে পারে না judgment থাকা। But just the root of the issue, if I may.
Whether LD can be imposed or not before the other forum, not here.
University kindly come to page 75.
Bear with me for 5 more
Page
minutes.
75 regarding jurisdiction only jurisdiction jurisdiction of the court
That is a
para 37 for any dispute para 37 for any dispute contact inspection action as in pursuance of general guidelines of vendor approval. Any dispute pertaining to tender contract, the court jurisdiction would be at the headquarters of consignee, Railway Delhi, for where contract has been issued, my lord. That is clearly said that on that point there are no objection, my lord. On the other hand, you should kindly come to my lord. একটু বলতে দাও আমাকে তুমি সব বলবে তাহলে তুমি বলো
No, then let me finish. No, let me just deal because he's raised the point of maintenance.
Yes.
Let's just deal
And
with it.
another point, my lord, you should kindly come
One
to
minute, he still has wants to finish.
Yes,
Yes.
I'll just deal with this issue. This jurisdiction of court, your lordships have time and overheld that this never excludes Article 226. Well, this is if the arbitration is invoked. Well, whether two aspects your lordship will kindly consider. Now, এটা নয় LD impose করতে পারে মানে your lordship will allow me to just cite this decision that liquidated damages can't be invoked. I'll tell you lordship why I'm showing it. If there is no it's just one moment that if it's wrong, then by MP power I can come in and do a maintain a
sufficient fine.
1 minute, please. 1 minute, please. Let him finish. Yes.
MP sugar mill জানো নি ওইটাই ওই MP power. This is Kailash Nath. Where is MP power?
One time, I'll give you
Just
time.
tomorrow, Milord.
Yes, yes. Please come. Had submission made on behalf of the petitioners. Stop. The petitioner intends to rely upon certain decisions in support of the submission that the writ petition will be maintainable. Stop. Released on next Wednesday, 16th.
Very good.
Instruction forwarded by the Western Railway, dated 7th July 2025. Be written with the records. You also come with decisions where writ petition will not be maintainable because of the contractual issues.
Very good.
না আরেকটা আছে না 11 নম্বর একটা আছে তো
I'm sorry, Milord, in my matter, the last one. The interim order that your lordship is granted is till the 15th.
All right.
Kept this on the 16th if that could
The interim order that is subsisting in the matter is extended till 18th of July 2025 or until further order, whichever is earlier.
Item number 5, passover matter.
Wait, there is one more matter.
Item number 11, we are on the last occasion.
Lordship, item number 11, I am appearing virtually, Lordship. From the previous order, my appearance has been expunged, Lordship.
Expunged?
June. My name has not been recorded. Respondent number 9 in person.
Maybe wrongly it has not been recorded. You have not been expunged.
Lordship, one more thing, I will just want to submit that I have preferred an appeal against that order.
Lordship, we may be heard, your lordship.
Justice Topabroto Chakraborty, and he
Against
has been
which order?
Against
dated
interim order,
25th
your
June.
lordship. They used to file
25th June.
appeal
Not
for
interim
every
order, Lordship. I am
it is
agreed
granted to
that
me.
this court is taking the
last
matter of
occasion,
police
your
in action,
lordship had
Lordship.
granted
There are
some
several
interim
other
relief to my
determinations.
family
This is the matter
members.
of police in
Against that
action.
order, they have
Should be
moved an appeal.
determined by the another coordinate bench, Lordship.
It is not fixed. Yesterday
Jurisdictional order.
afternoon at 4 p.m. he
I have
sent me a
served
mail
her.
that
All the respondents have been served with the copy of the appeal, and it has been fixed on 15th of July,
When
Lordship.
will the appeal be taken up?
15th of July. Just now, I have inquired with the court officer. They told that
Yes,
Honorable
what
Justice
about
has been
Very well, there is an interim order till 18th of July.
Your lordship, it is still 18th of July, but
yes,
but they have preferred an appeal on the ground which is not at all mentioned
You
anywhere.
mention it before the division bench.
Yes,
That
it
the
may
appeal
be,
is not
if
maintainable.
it is not taken up on 15th, it will be another year. It may be extended for few more days, Your Lordship. I will.
Let me hear.
Now, my lords, on the last occasion, his lordship has directed us, my lord, to file a report, my lord, with regard to these matters. My lord, kindly go through this once, my lord. Yeah, copy. Email is concerned, my lord. Yes, my lord, during, it has been mentioned, my lord, say, paragraph 2, my lord, the petitioner alleges so-and-so, false complaint so-and-so. During inquiry, it is learned that no such email message received at Howrah PS on 12/5/2025 by petitioner Malavika Saha. During inquiry about her allegations, it is learned that there were 2 complaints lodged at Howrah PS by one Sanjukta Samanto so-and-so against Malavika Shah and others, Vide Howrah PS case number so-and-so and second Howrah PS case number so-and-so dated so-and-so. During investigation, PS case alleged a person namely so-and-so were issued notice under section 41A. After investigation, PS case number so-and-so ended in charge sheet, Vide PS Howrah PS case dated so-and-so under section against 2 FIR name accused person namely Malavika Shah and Kumud Shah, block name so-and-so so-and-so, Konat Shah, sorry, my lord. So-and-so, so-and-so. And second, Konat Shah, so-and-so, flat number so-and-so, so-and-so. Another case, Howrah PS case number so-and-so is under investigation. This is the latest position of this
Your
matter.
Lordship, all evidences were given. I had sent the order also, but they will never receive my mail, Your Lordship.
Lordship, I have on humble
It
submission,
was on
Lordship.
official
mail.
Can
Your
this
Lordship,
bench hear the matter of police
I
inaction, Lordship,
I
outside
have
the roster
enclosed
set by
the
Honorable
It
Chief
is there.
Justice?
Please come.
Your Lordship, this matter is wrong
A
because
report
it
filed
is
by
on
the officer in
official
charge,
duty.
Howrah Police Station, dated 8 July 2025, filed in court today, is taken on record. ঠিক আছে? Who are you? You are the respondent number?
Respondent number 9 in person. Respondent number 9. Private
Respondent number 9.
number 9.
Submits that an appeal has been preferred from the order passed by this bench on 25th June 2025, and the same is likely to be taken up by the Honorable Division Bench on 15th July 2025. Stop. The dispute in the instant case is between legal practitioners. Stop. The court, now this bench hopes and trusts that the Honorable Division Bench will decide the issue conclusively. List the matter for further hearing on 18th. Pass over matter.
Obliged, Lordship.
Please make submission before the division bench so that it can be disposed of over here.
The division bench also, they have not served anything to the GP office. What they have done is, my lord, sent a email to my junior. This is the whole problem.
Do whatever.
And another, no, my lord, another
Mr.
thing.
Mukhopadhyay, please.
Well, myself and Porna went to Honorable Advocate General. Well, he is also not agreed to.
Just imagine the
What he
position.
says, my lord, what he says is, my lord, tell my lord that Advocate General is underground.
I don't want to be a further victim of any criminal case.
This has been
So he is also fed up.
Your Lordship, my husband was on official leave, Your Lordship, when he was implicated in this.
All this before the criminal court and make all submission before the division bench so that the division bench disposes of the matter
Your
and not
Lordship.
relegate
Yes, Your
here.
Lordship,
Right?
I'm just
So
tired of
whatever
this matter.
is to be done before the division bench,
Yes, Your
I'll go on adjourning the matter. All right? I make my mind clear. Yes, pass over. Yes.
I am appearing for the petitioner. The petitioner is as a working professional with the Dubai World International Trade Center, Your Lordship, pursuant to which the Dubai World International Trade Center has sponsored a visa valid till 2026, Your Lordship. Now, the petitioner's visa is expired due on 10th of October 2024, Your Lordship. Due to
You
which
said 26? Visa
is valid till 2026, Your Lordship.
Visa
The
is valid.
passport
Passport
validity is till October 2024 and pursuant 2024, October 2024, Your Lordship.
24?
Yes, we have applied. We have applied also, Your Lordship.
Expired.
We have applied prior to 2 months prior to that, Your Lordship.
All
And
right.
what happened is that the Dubai government, the Indian embassy at Dubai government has issued the passport, but the relevant police verification is still pending, Your Lordship. Pursuant to which the petitioner had taken a 2 months leave and applied for all the procedures to be done.
No, let me understand. In October 24, your passport expired.
Yes.
So you were
August,
there in Dubai.
I was there in Dubai.
When
August,
your passport expired,
Yes.
you were in Dubai.
no. But prior to that, I was informed that my passport was going to expire. So
Right.
August, I came back,
Right.
applied for all the procedures. Passport.
From August 24, you are here in India.
No, Your Lordship.
What no?
Then again, I came back with the old passport. I came back after applying. I came back to the Dubai to continue with my job. The Indian embassy at Dubai.
I did not get it, sir. Please make it clear. October was the expiry date of your passport.
Yes, Your Lordship.
When did you come back to India? In August.
August, I came back for the procedures to start
And then you went back.
with the old passport. Yes, Your Lordship.
And you are still there.
I'm not there.
You came back.
I came back again.
When? During the validity period of your passport.
Not during the validity period.
After your passport expired.
I'm telling you, explaining you the facts, Your Lordship. After
No,
I
give
had,
me the date. Don't explain anything.
after I had applied for the passport, Your Lordship, the Indian embassy at Dubai had actually issued the passport to me, particularly stating that the police verification is still pending. I need to go. There is a 1 year period under which I have to go and clear my police verification.
Yes.
Pursuant to which I had applied for a 2 months leave, Your Lordship, and to complete all
When
the
did you come
procedures.
back here?
May, Your Lordship.
25.
Yes. May applied for a 2 months leave, Your Lordship, and came back to apply for all the procedures that is to be done.
Let me hear, please.
Tendency of criminal case. As I
Is there?
Yes.
Hmm.
Two criminal cases are there.
Lordship knows very well that instead of approaching the Writ court, my learned friend should approach the
Your Lordship,
concerned magistrate and get a permission, because until and unless there is a permission from the concerned court, my lord, our hands are tied.
Your Lordship,
Lordship, this is the notification 570.
570.
570, Your Lordship. But
you-
there, Your Lordship,
Were you aware of the criminal cases?
yes, Your Lordship, I was aware. Your Lordship, I had actually I asked the police station for all the details, what is to be done. They did not tell me about the details.
You expect the police to tell you out as to how. it's
So
going to
I
get
have
it done?
given an undertaking as per notification 570, Your Lordship, and as per section 22A. What is there is
You
that
have
any
to
court.
obtain an order from the magistrate
Ye-
permitting you to depart.
I know, I understand,
Then
Your Lordship,
you
but
obtain it from there. Why are you
kindly refer to the notification, Lordship. It has written that any court can actually pass the order,
No,
not
sir.
the criminal court.
No, sir.
Lordship,
You are-
kindly refer to the notification, please. Kindly refer
is
to the
the
notification,
correct.
page 30 of the Writ.
Yes.
Lordship, page 30 of the Writ.
Who has given page 30?
The Writ petition, Lordship.
What is it?
31, Your Lordship.
Yes, what is
Particularly,
it?
the notification states that
Hmm.
excess of the power conferred under clause A of the section 22 of the Passport Act and in superstition of the notification of the Government of India in the Ministry of External Affairs dated 14th of April 1976, the central government being the opinion that it is necessary for public interest to do so, hereby exempts citizen of India against proceedings in respect of an offence alleged to have been committed by them are pending before the criminal court in India, who produce orders from the court concerned.
What does
permitting
it
to depart.
mean? What does it mean? Prior to making submission, you have annexed this document, you should have read it. See, against whom proceeding is in respect of an offence alleged to have been committed by them are pending before a criminal court in India and who produces orders from the court concerned. What does this mean? That the criminal court where the matter is pending, permitting them to depart from India. You just need to approach the criminal court where your matter is pending with a permission for given to you to depart. Obtain that. Why are you here before the Writ court?
Lordship,
Please come. The renewal of the petitioner's passport is pending, allegedly because of pendency of 2 criminal cases against him. Stop paragraph. The notification dated 25th August 1993 being GSR 570 within bracket caps E, issued by the Ministry of External Affairs.
Your Lordship,
Clearly-
just one indulgence, Your Lordship. The visa is going to expire tomorrow, and
So-
it's not the leave is going to expire tomorrow. If the petition doesn't go back, then he's going to lose his job, and the visa is
He'll
going
get
to get
some other
cancelled.
job, sir. That is not the only
Some
job.
direction is to be given, Your Lordship, because this is the court. To the police authority to take this matter seriously and expedite the matter.
1 minute.
I can in the meantime I can apply
Where?
before the court, lower
When?
court below.
Why did you
Lordship.
come here? You should have gone there immediately.
Also,
got an
Lordship,
order.
the next date is back in 2026 also.
You get it preponed, sir.
Anything, Lordship, any order of some sort? If
I'm
some,
so sorry, sir. You have to look for a job elsewhere, or have to wait till your passport is renewed. কি বললাম? Clearly mentions that uh, that if a proceeding is pending before a criminal court in India, then the applicant is required to produce orders from the concerned court permitting him to depart from India. Stuff. There are other conditions also which are required to be followed, mentioned in the said notification. Stuff. It will be open for the petitioner to take steps in terms of the subject notification. Writ petition disposed. Take this notification back and you can use it in the next matter.
My lord, these are very urgent matter, my lord. In the monthly list, item number 1791, which is already allowed in the Monday. My lord, this is a matter is senior.
The time to mention.
No, my lord, this is very urgent, my lord. Please
Urgency was
kindly
there
give me 2
morning?
minutes to hear.
Urgency was there in the morning. Why at 2 o'clock?
My lord,
This is not the way.
my lord, this is already been.
I'm not hearing you. Yes.
My lord, just 2 minutes, my lord. Just 2 minutes. Hear me 2 minutes.
Sir. Yes.
Unconditional apology, although this is not mentioning time, but my situation prompted me to come. Petitioner is a bed detained, took the loan. But he is not able to make the payment. I want that flat to be taken by the bank. Petition filed. Your lordship directed to file a report on the next day. Well, I am taking all these responsibilities of my junior. She was not well. This is for default item 520.
Today's list.
Today's list.
Are you aware who your other side is?
I have brought her.
Please wait. I'll take up matters immediately after I finish up the regular matters. I will take it up. Bring your other side.
She is there.
Yes, yes.
My lord.
Morning you mentioned bring your other side after I take up the regular. After I take up the regular matters, I'll come back.
My lord, please, my lord. This is a very.
I am not hearing you. Come tomorrow morning.
Lordship.
Yes.
Lordship. 20, my lord. In the morning, I.
Yes, you mentioned in the morning. Come.
And other side.
Give the serial number. File will be brought out.
Madam.
Item 1.
Madam.
520.
Item 1.
The Jalpaiguri matter, my lord, I am appealing for the petitioner, my lord. Today they have filed a report. From where the report they have stated the charge sheet already filed in this matter. The main contents of the main issue that the deed, the which was forged, they could not collected the deed as they could not collect the deed, main original deed, but they have filed a charge sheet. This is a record. They have submitted the report before me. Today they gave me the report, but my lord.
So you take steps before the learned trial court where the matter is pending. You make submissions. I'll dispose of the contempt.
Yes, your lordship. Yes, your lordship.
Yes. So where is the report? Some report has to be come over here. Yes,
yes, lordship. One person is there.
Yes, sir. Yes.
You submit the report before you.
From the report filed in court today, signed by the subdivisional police officer, Mathabhanga, Kuch Bihar, dated 10th July 2025, it appears that a charge sheet being Mathabhanga PS charge sheet number 386/2025, dated 19th June 2025, under sections, eta copy korben to. Against the accused persons has been filed before the learned trial court. Stop paragraph. As the charge sheet has already been filed, the court is not inclined to proceed with the contempt application any further. Stop. The same stands disposed of. Stop. It will be open for the petitioner to raise all issues before the learned trial court.
Grateful.
Disposed.
Grateful.
Lordship, our appeal kindly be recorded.
Yes, yes, certainly it will be recorded.
Grateful, Lordship.
Two, I am appearing on behalf of the contemner UDD. But here what happens, the order has to be passed by the Technical Municipality. Order dated March 2022.
Who are you representing?
For the petitioner.
Who are you representing?
Urban Development Department.
UD. Yes.
The contemner.
Lordship, I am
Right.
led by Mr. Lordship, I am led by Mr. Shubham Ghosh, who is engaged in court number 2 in circuit bench. Lordship, I am praying for the adjournment of 1 week, Lordship. Kindly fix the matter on any day and next week, Lordship.
Every week.
See, the learned advocate who is appearing for the department says that it has to be complied by the Mekliganj municipality. Where is the order?
The order is at page 26. It's an order of 10th of March 2022. The contempt application was filed in September 2023. So for that, the reason they have filed an application under section 5 also for condemnation of delay in filing the contempt.
What was to be done?
The repetition is accordingly disposed of by directing the Mekliganj municipality to take a decision in respect of the application made by the petitioners for grant of compassionate appointment strictly in accordance law within a period of 8 weeks. This is the operative portion of the order.
Where did you serve the Mekliganj municipality?
Lordship, I have no instruction regarding the same, Lordship.
Please come. Accommodation has been sought for.
Grateful, Lordship.
On behalf of the learned advocate representing the petitioners, stop paragraph. None appears on behalf of the contemptor number 2, Chairman, Mekliganj municipality. Stop. Let further notice be issued upon the non-appearing contemptor. Released 24th July.
Grateful, Lordship.
Number 193. I am for the applicant.
Yes.
As per your lordship direction, whether the alleged contender is present before your lordship.
Who is he?
Director of Employment, my lord. The order has been complied with, my lord. In the meantime, as per the direction, my lord. This was for the enlistment.
2000 or the 14. Last, my lord.
Contempt is of 2014.
Yes.
Well, the reason is, my lord, I have stated the last occasion.
The person appearance, they file a recalling application before the division bench. That application dismissed. Then
no, that has been dismissed. No, in the meantime, we have proceeded with, my lord.
Kindly see the last order. What is the type of conduct of the contender, my lord?
Finish করতে নিতে না আমি তারপর আপনাকে ওটাই বলছি মানে so far as the delay is concerned.
Yes.
So far as the delay part is there, my lord, we tender unconditional apology for the same, my lord. But at the same time, I repeat, my lord, that appeal was filed within time, and my lord, on that basis, there was an interim order initially, which has been dismissed in 2023. Lordship, on the very first day when I came,
what is the age of the petitioner now?
Now, my lord, 54.
54.
Yes.
10 years have passed in the meantime. How and when will you consider her case?
The reason is, my lord, kindly consider, my lord, that
no
kindly appreciate, my lord.
No gender discrimination. The appeal court has held already. So you have to give the benefit to the petitioner. There was a direction to enlist the name of the petitioner in the exempted category under the heading land loser.
Yes, and that has been done, my lord.
Now doing it makes no sense because she will not get a job.
My lord, so far as my instructions are that there is a there is a provision for condonation of that age limit. Overage can also be considered in certain cases.
This is the only 5 years that is gone.
Overage may be condoned, but what will be her service career?
In that occasion, my lord, may I don't take me otherwise, my lord, that there was a stay.
till 2023 for dismiss for default, the petitioner has not taken any steps for the dismissal of the appeal or the hearing of the appeal, my lord. It was kept pending only on 2023, my lord. This got dismissed. And
the appeal was preferred by you in 2016.
Yes. 2016.
Right.
There was an order of stay at that point of time, initially.
Now,
my lord, I have already shown that order also on the last occasion.
what can be done? This is the fate of the petitioner. I cannot do anything. Please come. Compliance report has been filed by the contender. In closing, an identity card issued in favor of the petitioner on 2nd July 2025 to show that she has been enlisted under the exempted category by the Directorate of Employment. Stop paragraph. The order of the learned single judge appears to have been complied with. Stop. In view of the above, the contempt application stands disposed of. Personal appearance of the, give the name of the person. Such and such. Designation.
Director of
Stands dismissed. Stands dispensed with. Take this back because
we tender unconditional apology for whatever delay has been caused, my lord. I'm grateful, my lord.
194, my lord. I am appearing on behalf of the alleged contempt. My client is present in court, my lord.
Who is she? Who is she?
Pradhan, my lord.
Pradhan of the Gram Panchayat. Why did she not comply with the court's order?
I am praying, my lord, an unconditional apology on her behalf, my lord. My lord, I am praying for a fortnight's time, my lord, to comply with the order, my lord.
When was the order passed? 5th of February 2024.
Yes,
right? And we are in July 2025. There was a direction for compliance possibly within 4 weeks?
4 weeks.
4 weeks.
4 months.
4 months. 4 months.
Within a period 4 months, right? So 4 months expired long ago. Illegal and unauthorized construction. Why has steps not been taken?
My lord, actually an inquiry was held, my lord, but it was not in accordance with the order, my lord. That is the whole problem, my lord. My lord, kindly grants a fortnight.
What is the qualification of the Panchayat Pradhan? She could understand what it is. She could have taken the assistance of a learned advocate or the executive engineer of the Gram Panchayat. Why did he sit tight over the matter? File your compliance report. Please come. The order of the court has not been complied with till date. Did you file your Wakalatnama?
I shall, my lord, by today itself.
Please do. The Pradhan of the Gram Panchayat is personally present in court. Though there was no direction for her personal appearance. Stop. Learned advocate for the contemptor seeks unconditional apology and prays some time for compliance of the court's order. Stop. In view of such submission, hearing of the contempt application stands adjourned till 21st August 2025. An affidavit of compliance shall be prepared and circulated by 14th August 2025. Affidavit of service taken on record. Please advise her and guide her as to how the order of the court is required to be complied with.
Great.
195 and 196. My lord, in these two matters, for contender number 2, Mr. Somnath Roy Chaudhary is appearing. He is on his legs right now, my lord, and 5 minutes pass over, my lord. I'm praying for.
What is the matter?
That matter, my lord, regarding pension, my lord, your lordship already heard those matters.
All right.
Two matters, my lord, and my lord directed to release the pensionary benefit, my lord.
It has not been released? All right, wait, he's coming. Please wait. Yes, please. You are for?
Pass over, my lord.
Well, what is your submission? You are here in this matter?
Yes, my lord. I
What?
am for contender number 1, my lord.
Who is he?
The DM Murshidabad, my lord.
Yes.
The main disbursing authority is contender number 2, my lord.
All
the
right,
DM.
2 is coming. Pass it over for the time being. 197?
My lord, I am for the petitioner.
Contempt.
Here.
With 198?
Order for
By Mr. Royan Banerjee in this matter.
With 198?
198.
197, is it with 198?
I am for the petition.
Lordship,
Are they together?
No.
No.
188, Mr. Sandeepan Banerjee is appearing on behalf of Howrah Municipal Corporation.
দেখুন ভুল করে হয়তো হয়ে গেছে।
My lord, 197 is mine.
Separate.
Separate.
Nothing to do with
Nothing to do
198.
with one.
দেখুন লিস্টে হয়তো ভুল করে এসেছে। ওটা তো সন্ধ্যা ভট্টাচার্য।
No, my lord.
CRC is there, I see. দেখুন কার সাথে কি মিলিয়েছেন। Yes, what is it? Has the order been complied?
No, my lord. My lord, there are two parts of the order. My lord, this matter is coming for the first time. The second time. My lord, they sought for time on the other day. My lord was pleased. This was fortnight back. My lord was pleased to keep it.
26th of June 2025.
Yes, my lord.
5th September 2022 order has been violated.
My lord.
By that order, what was the
My lord, there are two parts of the order where my lord will kindly come to the last part of page 2 of my lord's order, where my lord says inspection shall be conducted by Bali municipality within a fortnight from the date of giving prior notice to hearing to the petitioner, the private respondent. The administrator Bali municipality is directed to pass reasoned order, my lord, which has been passed, demolition order. If it transpires, my lord, subsequently at page 2, if it transpires that that transpires upon inspection that there is any unauthorized construction, the necessary steps shall be taken by administrator Bali municipality, deal with the same in accordance with law. My lord, so the demolition
order has been passed.
Demolition order has been passed, tested and affirmed in appeal, the statutory appeal. My lord, then Bali and police is playing a chicken and egg situation. Bali is saying that police is not assisting me. There is a police order also from Justice Titangor Ghosh's court to give me assistance. And the police is giving a report that because my lord had prevented any third party but there is an interim order without any to prevent any third party interest.
Yes.
My lord, police is saying that it can't be vacated unless there is an order. There are occupancy in the property unless there is an order.
All right, let me hear. Let me hear.
We passed the order. The date of demolition was fixed. Demolition squad went there. Now it's full of inmates. Police was also there. They are saying that there is no direction on us to vacate. We cannot vacate. You vacate. We shall maintain peace.
My lord will find a 70.
Personnel of the municipality, my lord, to
forcefully vacate the inmates, that is possibly not possible unless the police helps us, because they have to be forcefully evicted. Now, police is saying it's part of the exercise. They are supposed to vacate. This is the only obstacle. Kindly come to page 74. This is a report of the executive engineer.
Jana Babu. You have not implemented the police as a party?
No, my lord, because the direction was initially upon them. I was technically barred.
But the OC was a party in the writ petition.
Perhaps. But the direction was on Bali Municipal.
For compliance of your lordship's order, you sought for assistance?
Yes. Show me that you sought for assistance. Is it an
Page 74, this is a report of the executive officer. Resolution, Lord, of hearing.
74. Yes.
Last two paragraphs. Vishwas, Sub-Inspector Belur PS, submits that in this particular case, there is no specific direction upon Belur PS given by the Honorable Calcutta High Court for vacating the suit premises. That's why they could not vacate the suit premises as sought for by the administrator for demolition work. This is the only obstacle we are facing.
And my lord, in the order in contempt, my lord had specifically restrained them from creating any third-party interest. That was there. My lord, subsequently, my lord, contempt was
Please come
before my lord. My lord.
The order of demolition passed by the Bali municipality. Cannot be executed because of the occupants refusing to vacate the portions constructed unauthorizedly. Another appeal was preferred. Title appeal I can see.
My lord, it is. What has happened? My lord, they have tested it in appeal. The demolition order, it was affirmed thereafter.
Thereafter?
It was affirmed, my lord. The appeal order is also have annexed.
Thereafter?
They have preferred another appeal against this, the order of the appellate court, which is possibly not permitted in law.
Well, there
under
is
18.3, there's only one provision for
kept
appeal.
open, my lord. No order is passed. Maintainability, we've challenged the maintainability, has been kept open.
Possibly that appeal is not maintainable.
Handing out the order, that appeal, that is absolutely not maintainable. No.
The Bali municipality sought for assistance from the Belur PS, but the same has not been provided as according to the police, there was no specific direction for vacating the premises.
My lord will kindly consider 68, my lord, at page Tirthankar Ghosh's order. Police assistance was also directed. Point of view.
Where the page 68 is, there is nothing mentioned with regard to the demolition. It's an absolute, nothing can be understood from this order as to why this has been passed. Prays for protection at the hands of certain hooligans. To that effect, she has expressed insecurity and informed. Police has been directed. Nothing.
My lord.
As it appears that the order of demolition is to be executed, the inspector in charge, Belur police station, is directed to use reasonable force for the purpose of vacating the portions constructed unauthorizedly so that the municipality can proceed to demolish the same. Stuff. Next. It will be open for the inspector in charge, Belur police station, to seek for additional police force from the Commissioner of Police, Howrah Police Commissionerate, if occasion so arises. Stop. Paragraph. The Bali municipality shall demolish the unauthorized construction and file a report before this court on the adjourned date. Stop. released the contempt application for further consideration on 21st August 2025. Stop. Paragraph 20. Be it recorded that the
OC Belur PS may be added as a
officer in charge Belur Police Station was impleaded as the respondent number 4 in the writ petition, where order was passed by the court, contempt of which has been pleaded. Will it be officer or inspector in charge? The IC Justice Tirthankar Ghosh's order, it says officer, inspector.
in charge.
Here it is mentioned officer. Officer / inspector করে দিন। Officer / inspector. ঠিক আছে? কি ছিল?
Need not be added as a party because
No, this is a direction. I'm grateful, my lord.
যেটা বলছিল এখন ডাইরেকশন হয়ে গেল এখন let them
অন্য রিটটা ডিসপোজ হয়ে গেছে, এর মিলিয়ে দেখতে হবে। In the list checkup, it is Rakesh Kumar Nayak. It is item number 198. It was tagged along with this matter.
It is not a party probably.
Where?
Can I'm
Bali is not a party in the writ.
This three Bali is the party.
Bali is a party.
Out of which this contempt.
Yes, Bali is a party.
Next matter, probably the order sheet shows that it is only HMC. Alleged contempt আমাদের নাম নয় এগুলো।
It is a WPA, not separate. It was tagged. If I can remember correctly, I have not checked up. Possibly this has been filed by the occupants. Find out?
আমি তো জানি না আমাদের তো
চেক আপ
Yes, একটু ফাইলটা ওনাদেরকে দেখান, ওরা দেখে নেবে। টেমটা ফাইল করেছে তো ওরাই। Yes, call the next matter.
না রাকেশ কুমার না
কি দাঁড়াচ্ছে দেখি এই তো হ্যাঁ অপূর্ব কুমার ঘোষ
এটা দরকার নেই, ফেরত দিয়ে দিন।
কোনটা রিট পিটিশন ওটা ওদের
Yes, call the next matter.
রিট পিটিশন দিস সেপারেট রিট পিটিশন
Separate writ petition possibly filed by the persons who were occupying the unauthorizedly constructed portion for stay of the hands of the Bali municipal.
in the read
If I am not wrong.
executive officer is the
two
party
writs were heard analogous. One writ was mine and the other was by the developer.
Yes, it is this matter.
This is this matter.
Bali was added Lord
নিচে WPCRC
যেরকম ট্যাগ করা আছে থাকুক, দেখা
হ্যাঁ।
যাবে। Yes, call the
CRC টা disposed of CRC টা
Lordship direction, Lordship. Directed the Lordship direction of the district inspector of school to pay the ADR pension, CPF to GPF, Lordship. Victoria Lordship. ADR already been given during pendency of the contempt application, but Lordship direction was at the rate of 7% from the 1st November 2019 to till the date of that interest part has not been payment.
And so what interest is concerned, my lord. So far, party has been made contemptor. The officer, he has paid the entire money except the interest part. He has not. Interest part, my lord, that the instruction to me by the law officer of the DPPG that the appeal is pending with regard to the matter. My lord.
Appeal is pending?
Against the matter.
My lord, see. Second paragraph, last 4 lines, and the third paragraph.
Second paragraph, last 4 line. You know the employee will get pension in the clarification judgment of CPU in all of us passed by all of special bench and other target. They said they will get their pension from the date of the retirement. If they have
Mr. Bhaskar Basu has been engaged in that matter. Let's file the appeal.
in this order, there is a direction for payment of interest? There is a direction for payment of interest in this order. Why has interest not been paid? Where is the appeal pending? There is no direction for appeal.
Initially, contempt application, DI was made a party as a contemptor. DI has paid his entire money, the permanent fund. But the interest part on the permanent fund being created, that is to be paid by the, that is there in the my file has been sent to the person concerned who is, he wants to make a party there in the another, in this party, particular.
He doesn't want to make anybody as a party.
Ask my friend to file a separate application so that.
For what?
No, subject to. I mean,
for what?
That now he's
come.
No, he's bringing another person, madam.
Who is bringing another person?
That is another.
Lordship direction was DI Lordship all.
Only the DI also.
No. It appears from the submission made on behalf of the parties that though the principal amount has been paid to the petitioner, but the interest that was directed to be paid at the rate of 7% per annum from 1st November 2019 till the date of actual payment has not been disbursed. Stop. The hearing of the contempt application stands adjourned till 21st August 2025. The
Treasury officer.
The treasury officer will pay.
Concerned officer shall disburse the interest in terms of the order passed by the court. Stop. In the event the interest is not paid in terms of the direction passed by the court, then the District Inspector of Schools, Primary Education, Purva Mendipur, shall remain personally present in court on the adjourned date.
Interest part will pay the treasury officer.
Whoever it is, your officer. Your officer will take steps to get it paid.
But he has nothing to do with that, my lord.
Very well, he will come here every day. I'll bring her every day. Bring him every day.
Lordship, fix the matter.
21st of August.
Lord, I appear for the petitioner.
Yes.
Sir, I appear for the Union of India.
But I appear for the respondents number 224.
What is the application for?
This is an application for Lord taking out a proceedings for perjury against Lord the person Lord who had affirmed an affidavit in the proceedings in the writ petition in opposition to the.
Who is the person who affirmed the affidavit?
I'll just give your lordship the name. It is the
designation. Designation.
I'll give your lordship. It's a Rajesh Kumar.
Designation.
General Manager of Insolvency and Bankruptcy Board of India.
And what is the incorrect averment made?
I tell your lordship, there is a proceedings which is Lord going on against the petitioner who was holding a license to act as a resolution profession. Now, Lord, this license has been cancelled, and pursuant to which this writ petition has been filed. The writ petition was admitted. The penalty amount was asked to be kept in a separate account, and Lord, the writ petition is pending. So, Lord, this affidavit has come by of an opposition to the writ petition. If your lordships kindly come to page 19, Lord, of this, there, Lord, there is an averment with regard to certain orders being set aside by the Supreme Court. Your lordships may kindly straight away come to page 34. And that is affirmed as true to his knowledge.
34.
Yes. Kindly
yes.
Come to the last line.
Yes.
The directions of your lordships kindly come to the last line. Page 34.
Is it can 1 of 25?
Can 1 of 25. Page 34.
The last three lines.
Last three words of the last line. Your
the directions.
The directions of the learned National Company Law Appellate Tribunal to set aside the order dated such and such along with November 20, 2019 would reflect the inefficient manner in which the corporate insolvency resolution process was being conducted by the present case. So, my lord, he says that there are two orders which has been set aside. One is dated 7th February 2020, other is dated November 20, 2019. And this is affirmed as true to his knowledge. Your lordships will find at page 45.
Yes. Yes, then.
And that reflects his conduct. This is basically they're saying that it reflects his conduct insofar as conducting this resolution proceedings is concerned. Your Lordship, kindly come to page 45. It
Yes,
says
yes. True to his
everything
knowledge.
true to knowledge. Now, my lord, there was a under the Right to Information Act, and a query was raised. Kindly come to page
Tell
129.
me one thing. Why don't you all proceed with the hearing of the writ petition?
Yes, yes.
Kindly do it.
No, we are also, we
No, no,
also want that.
Kindly.
You know, the level of dishonesty of this resolution professional
Whatever.
is unbelievable.
I did not open my mouth
Yes, yes.
with regard to the conduct of the Insolvency Bankruptcy Board.
Yes.
Kindly, my lord, fix it. I have no objection. Kindly.
Before any other bench, you please try. This bench is heavily burdened.
This is a very short matter.
Maybe the volume does not say so.
But that is because.
But may I also request your lordship, my lord, joint prayer to take up, my lord, whenever your lordship gets a
Thing
little
is,
time.
pressure is so much. It would have been nice if I could have accommodated you. I give you leave. Why don't you try out before any bench taking up hearing matters? You can get it done over there.
The difficulty, I am told that there are difficulties.
Difficulty over here also. You see the pressure of the bench. Every day the motion pressure is such that the hearings.
Can I suggest something? Lord, there is a working Saturday which has been suggested.
You want to trouble the bench with the working
I don't have a
Saturday?
problem. I'll come on the working Saturday. I'm interested, my lord, to do
Now
the
this
matter.
bench will come also on a working
I want to
Saturday,
do
but
it,
I
sir.
have got other works to do also, please.
No, but,
Ashan to dekhi.
My lord, both sides, my lord, want to do it for your lord.
It's a time constraint only, nothing else.
Lord, in that event, Lord, kindly give directions for filing affidavits in this matter.
Again, the volume will
No,
increase.
it should be
Now
dismissed at the
the bench
threshold.
who will hear is so much of volume. What you will
I
hear?
thought, Lord, the main matter is going to be heard. That's why.
Yes.
But otherwise, Lord, let him at least file an affidavit.
No,
Why
my
this?
lordship will consider
deliberate-
whether or not to
why this
dismiss it
de-
at
why
the
this
threshold when I show that other judgment.
Keep
I'll
the
check it.
maintainability
No, this is for the purpose of pressurizing honest
The-
government officials.
Yes, very honest.
You are the writ petitioner.
Yes, Lord.
Achha, the writ petitioner has filed an application for initiating proceedings for perjury against one of the respondents in the writ petition for swearing false affidavit before the court. Paragraph. It appears that our opposition and reply over.
In the main
The
matter,
writ-
I think over.
Main matter.
Main matter is over.
Main matter is over.
Yes.
The affidavits in the main writ petition are over, and the matter can be treated as ready for hearing. Stuff. Due to the pressure of motions on this bench, the court is not in a position to take up hearing matters at this stage. Stuff. It will be open for the parties to approach any other honorable bench taking up hearing matters for getting the writ petition heard.
But along with the application.
Along with the connected application.
Much okay.
One or two applications. How many are there? One application or two?
One, I believe, my lord.
One. ঠিক আছে দেখে নেবেন একটু. Yes.
I'm sorry. There are একটাই তো।
One.
There's only.
Yes.
Great.
Your lordship, for the alleged contempt, there was a two direction from your.
Serve the compliance report.
This is the complaint.
Did you go through it? Did you go through it?
My lord, I just upon perusal, my lord, kindly takes paragraph 8 onwards.
Order not complied.
Order complied, my lord, but there is a unauthorized construction.
Your lordship, there are two submissions, two steps before that. As it is fallen from your lordship, there has been an unauthorized construction. The ground floor, there is no unauthorized construction. From the first floor, there is a 250 per square feet unauthorized. We have already noticed the concern promoter, your lordship, but the difficulty is that kindly come to page number 11, your lordship. Apart from the ground floor, there are such many occupants over there.
who are not a party to any part of the litigation. The ground floor is, we have found that there is no illegal construction. The map has been supplied. From the first floor to the fifth floor, there are illegal construction of 261. The cantilevers have been brought before.
You take steps.
Yes, kindly see the note, see page number, Your Lordship, 14. We have already given notice to the concerned promoter to kindly clarify the position. As per, we will take action as per the law. That has been served to them. The order is that, Your Lordship, page 10.
Yes. Page 14, you give the notice. Order is at page 10. That the origin construction is violation of the sanction plan. All right. So they have at least taken steps to deal with it. Please come.
Your Lordship, as per Your Lordship direction, the chairman
Complaints
is present online and the other contemporary is present physically, Your Lordship.
When was the order passed?
Your Lordship.
22.
Yes, 22.
And in 25, the order is yet to be complied. Why will the contemners not be taken to task?
Your Lordship, the difficulty was that definitely, as I have followed the instruction, that if Your Lordship go by the order, it was submitted as a newly constructed building. No, there was no occupant. But when we went over there, there are multiple occupants, Your Lordship, because
there will be occupants in unauthorized construction. Does it mean that you will not take steps?
Your Lordship, I bowed down as we have
22 to 25.
We have started taking action, Your Lordship. Kindly acknowledge that. An unconditional apology for the delay, Your Lordship. We have
unconditional apology is just lip service. I do not see any remorse on the part of the authorities that they have been delayed. And why they are only unconditional apology? That means you are supporting the unauthorized construction.
If you have supported, you have never issued the notice. Your
That is on the pressure of the bench.
No, Your Lordship. We are taking steps. The follow-up action also will be taken, Your Lordship, because we have started the procedure now.
Our compliance report, it appears that the municipality has lately started taking action against the unauthorized construction that has been detected. Notice has been given to the developer only in the month of, only on 26th of June 2025. Where is the proof of service of this letter? Page 14.
Your Lordship.
How did you serve?
By hand service, Your Lordship.
You have the receipt?
Yes, they have accepted.
All right. Next. The contempt application stands adjourned till 28th August 2025. Let an updated report be placed before this court on the adjourned date. Personal appearance of give the names of the persons who are present. Stands dispensed with for the time being.
Deeply obliged.
In this matter, Your Lordship, I beg to appear for the petition, Your Lordship.
The pension matter, my lord, already PPO has been released.
No, that was recorded in the month of May. PPO has been received. Did the money flow to your account?
No.
Why?
The DPPG already released it, and they have not made any party to the DPPG or anyone. We have gone to the place and we have done it, everything. That we have already got the PPO released.
Did you check up with the your bank whether the money has come or not?
Yes, Lordship.
What?
They just called me just before some time and stated that no amount has been transferred to his account. And Your Lordship, the parent order, page number 2, the respondents were directed to release the terminal benefits. Now, Lordship, terminal benefits also includes gratuity, provident fund, and other things. Lordship, pension and the arrear pension, that is also not been paid.
Gratuity is over here. Gratuity is included in your PPO.
Let him get a copy and come with a.
No, on 26th May, you submitted that PPO has been issued.
That is there, my lord. That date is there in the PPO. 26th May. At that right hand side at the top.
This is June. This is 26th of June.
June 20. Oh, sorry, my lord, I have missed it, I think. 26th of, yes, 25th of June, my lord. Sorry.
Yes, it's in June.
25th of June.
But then today is 10th of July. You should have got the money by now. Check up. Take a copy of the PPO and check up.
I have given a copy.
Please come.
Their transfer lordship is, they called me today in the morning also. They stated that no amount has been transferred to his account.
Check up where it is stuck up, because right now municipality cannot do anything. The PPO is there in your hand.
Well, I will take instruction from the client lords. And they could have made a party to them also. In any manner, we have
Copy of the pension payment order dated 25th June 2025. Placed in court today by the learned advocate representing the petitioner. Is retained with the records. Stop. Copy of the same has been handed over to the learned advocate representing the petitioner in court today.
No.
Stop. The petitioner is directed
by me, ma'am, not
Yes.
the petition.
কি বললাম? The petitioner is directed to follow up the matter. Stop. Released for further consideration on 24th. Fortnight's time. Please check up where the money got stuck up.
Obliged lordship. আপনাকে দেখেছিল? Today morning, they have called him today morning.
No, he inquired today morning.
Yes. No, they have called him. His client has. Obliged lordship.
I am for the petition.
I am for the that
Water connection given to all the.
last order connection was also given, but fact is this, my lord, regarding the other, they could not have shown the association.
No, he says order complied.
Those who have made application,
There.
No, now, my lord,
Others, we are not concerned.
that should
At
be
least not in this matter.
no, they are association in the matter. Association is in the matter.
Yes.
They have claimed that they are members of the association. Fact is this, they have not approached.
No application is pending till date. That is my instruction. Lordship, kindly
So
record.
in that matter, my lord may dispose it.
I'll dispose it off. Learned advocate for the petitioner submits that the order of the court has been complied with. Stop. In view of such submission, contempt application stands disposed of.
Obliged.
A copy of the electrical.
Give. Copy of the water supply connection certificate. This is only one.
That is the last one.
Last one. No, you keep it with you. If he says it has been complied, দরকার নেই।
Then that may be recorded that we have complied.
Yes.
That he admitted.
Yes. Petitioner submits that it has been complied.
Yes.
Yes. 205.
I appear for the alleged contempt on the last occasion. Well, I took certain time for my lordship to look into the papers because that information I did not. But I find, my lord, that prima facie that your lordship's order is 7th July 2023. Your lordship looked at the order. Your lordship passed a detailed order. And my lord, at the end, your lordship say that page 4, the allegation of the petitioner that there has been another construction appears to be a hollow one and cannot be accepted by the court. Then, in the event, the petitioner files a representation clearly mentioning the details on the unauthorized construction. Then the corporation shall consider the same in accordance with the law after giving a reasonable opportunity of being heard. Well, I don't find also by inquiring of my officers whether they represent, because in the event he makes a representation giving details of the unauthorized construction, that is to be taken into consideration. But neither he has annexed to this petition that the representation which has submitted to the authorities immediate after your losses order. And my lord, also my lord, I inquired from my department that whether you received or not. They instantly could not, my lord, provide me that. But the thing is that the offer after in view of that order, my lord, in earlier proceeding the public interest litigation or something else that we proceeded, my lord, accordingly whatever the construction was found authorized unauthorized, that has been dealt with, and by the special register building, my lord, has been, my lord, passed an order. Then, my lord, under the regulation, it has been forwarded to the Mayoral Council. The Mayoral Council, my lord, on that issue, because the notice on the basis of this any application made by the petitioner, that Mayoral Council, my lord, wrong possibly, in my understanding, that is a wrong notion that since it is the contempt petition is pending before lordship, but he has held up the matter, he has not proceeded with the Mayoral Council, But I have instructed the department that pendency of this contempt petition before the court does not stand in the way of taking a decision with the Maritime Council in terms of that regulation. Therefore, it is now at the stage. But if your lordship clears the
So
intention,
you detected unauthorized
unauthorized construction and of our own my lord proceeded.
401.
401.
401.
And the special officer building had also passed an order.
Yes.
Twofold orders are there. And that matter has all been forwarded to the Maritime Council.
Hmm.
Maritime Council, because of the pendency of the matter,
Very well.
already put an advice
What is your submission?
that he has not made any representation.
What
Because
is
that
your
is
submission?
Being led by Miss Akanksha Mukherjee, she was supposed to join by the VC. However, she's not being able to join presently. I seek a short passover.
Please come. Learned advocate representing the contemptor submits that unauthorized construction has been detected and the file is currently pending before the mayor and council for approval of the steps taken by the special officer. Special officer building, within bracket building. ঠিক আছে? Learned advocate representing the petitioner seeks accommodation. এটাকে ফার্স্ট প্যারাগ্রাফ তারপরে ওটা দেবেন আচ্ছা release the matter for further consideration on 31st July 2025. Learned advocate representing the contemptor / corporation shall produce an updated report on the adjourned date.
Lordship making it 31st July.
Yes.
But I am for the school authority. But only today morning I received notice from the school authority. The matter is in the list.
Last night I have served notice upon the my lord.
Yes,
School,
from school authority I received the notice that today morning only. My lord. So I made
What's the matter?
Matter is my lord, release of salary, my lord. My lord, my caste certificate was cancelled. Thereafter, that order has been stayed, my lord.
Why will this bench take up? Is this a contempt?
No, my lord. This is
Then-
application for release of salary, my lord.
Why this bench?
Because, my lord, this bench, my lord, because caste certificate was cancelled, that has been stayed. That is the determination of this bench, my lord.
All right.
Yes. What happened, my lord? The caste certificate cancellation order has been stayed. Thereafter, the pursuant to the order of this honorable court, I was allowed to join the school service, but they are not releasing my salary, my lord. That is the only contention. They are saying unless the
Show me
Yes,
that.
kindly seize, my lord. Page 2, my lord. My lord, kindly come to page 12 of the order. That is the person to which order I was allowed to join the service, my lord. Relevant page is, my lord, page 14, paragraph 10. Hence, the respondent number 4 and 5, that is the school authorities, are directed to permit the petitioner to carry on with
Yes, I can see the termination order has been stayed.
What happened
And-
thereafter, my lord?
Yes.
I joined the school. They are saying unless the court orders for release of salary, that is verbally, they will not, my lord, release the salary. That is the conduct of the court.
Show me your joining.
My lord, thereafter sees that is the order allowing me to
Join.
That is at page, my lord, 16. That is the school's communication. After intervention of the DI
Please
of
come.
yes, my lord. Thereafter, my lord,
we take it on next Thursday, my lord.
The
Okay, one week, my lord.
by virtue of the order passed by the court, comma, the petitioner has been directed to join in the school with a communication dated 10th May 2024. Stop. Allegation of the petitioner is that he is not being paid his salary despite joining service. Stop. Paragraph.
since May 2024, my lord.
1 year you
One
not
year they are not releasing on the plea that unless court directs.
আচ্ছা, ঠিক আছে. As the petitioner has been permitted to join in terms of the direction of the school,
Next Thursday, my lord.
in terms of the direction passed by the court, comma, the authority will be obliged to pay the remuneration of the petitioner. Stop. Hearing of the contempt, hearing of the applications is adjourned till 31st July 2025. Stop. All arrear payment due to the petitioner shall positively be released prior to the adjourned date. Service is taken on record.
They are not keeping attendance register separate for me. They are not allowing to sign in the register, which is made for other staff.
All right.
Because
Take your salary.
because we have sufficient evidence to show that he obtained the caste certificate fraudulently, because all other family members are not belongs to general category.
Yes.
Well, this is my application for review of your lawsuits order. Well, I request your lawsuits, kindly have a look at your lawsuits order first. Order date, section 5 is there, 4-5 days delay. I think my management will not stand for delay. Any all of that's formality. Stay application page 28. Your
I see an application for restoration is there.
That's application for condonation of delay that was probably dismissed, that was restored, and then that original condonation.
That has not been restored.
But other original applications have been allowed and restored.
This is a restoration of the restoration application.
That was there. That was allowed by your lordships.
Then what is this? Can 3? Yes, can 3 is disposed of, it is restored to its original file. So review is to be taken up for consideration.
Can 4 also. Now, your lordships, what order I am praying for review, dated 28 November 2023. If your lordships just 3 pages order, kindly go through it, and then I will make my submissions.
But at the outset, I submit, but I will be filing an affidavit to this application because of reasons. Yes, I shall.
Let them do that. Unnecessarily, I will not take point to your loss time. If they want, but if your lordship prima facie wants to be satisfied, I will.
Memo of review may be supplied. I have requested my senior friend.
That I can satisfy.
28th November 23. Very well. If he intends to file a review, opposition, let him file.
That's your loss.
Because of the reason lordship kindly comes to page 23.
Then I will allow me to make submissions.
Which portion of the order do you want to be reviewed?
The first point I tell you, lordships, the photograph. My lord, kindly come to your lordships. Very first paragraph. My allegation was in regard to 1 Kane Chatterjee Street, Bali. That's your lordships. Now your lordships have been shown your lordship page 3 of your lordship's order, the very first 2 paragraphs. Now your lordships, I take your lordships. These 3 paragraphs relates to photograph. In the Writ petition, this was the photograph. I for your lordships.
Yes. Then what happened?
In the bottom, your lordships find 18 Grant Road. 18 Grand Trunk Road.
Achha.
That's probably your lordships wanted to
18 Grand Trunk
Road.
Road.
This is a photograph of 18 Grand Trunk Road. You are misleading. My lord, any GPS time stamp camera. Suppose, my lord, my mobile phone has a app, GPS time. If I take a photograph from here of that Almira, location will be shown here. Photograph will be there. So this is the, my lord, mistaken. This was not pointed out to your lordships that the photograph is right one. This is the unauthorized building. I took this building photograph from the...
No, then the court has directed the municipality to decide what is the difficulty.
But I take your lordships. This is the first one. Second one, I tell your lordships. What I'm facing your lordships. The second, your lordships, the photograph point is absolutely, my lord, according to me, not right. Second, your lordships, kindly see the first page, second paragraph, submissions that I am extorting money. Making complaint.
Yes.
Then that's your lordships reiterated in the habit of extracting.
Yes.
My lord, I am a right to information act activist. Not only unauthorized building. I have my public interest litigation is pending before the Honorable Chief Justice in respect of NDPS, arrest persons, those who have been falsely implicated. Now, I tell you, I have annexed several documents, judgments, even if your lordship's judgment. Because I do this, I have been implicated in 9 criminal cases. In 7, I have been acquitted. I have still given the particulars. Only 2 are still continuing. What the municipality is trying to do that, they are helping that person till date they have not taken any step pursuant to your lordship's order.
Then you file a contempt.
That's another aspect, your lordship.
Where is the ground for review?
The impression of your lordships that because of this, whenever I now want to make as a right to activist, a right of information activist, any complaint, police makes me a call. Look, that judgment is there. We will arrest you again.
Where is the order of arrest?
I have given the particulars. Not here. They are threatening.
No, that is something else. That has nothing to do with the review of the order.
Your lordships kindly see how this was dismissed. Your lordships kindly see even.
Yes.
Now your lordships kindly see page 3.
Yes.
The officer in charge, Bali's police station, is directed to inquire into the antecedents of the petitioners. To inquire. So, my lord, I am saying there are 9 cases pending against me. Everywhere I have said it. Out of 9, 7 I have been acquitted by the competence.
Very well, you have been acquitted.
But your losses because of this is a racketeering. This is not the fact.
Listen, the officer in charge has been directed to look into your antecedents. That does not mean that he is going to arrest you.
No.
If you have a case, you say you have been acquitted.
Because this prompts them to threaten me.
Take steps against the police.
Therefore, this is the
no ground for review. Please come. Sorry. Please come.
And so for the photograph,
the petitioner.
And your losses kindly have a look at this
Sixth
order.
review of the order dated 28th of November 2023.
Your losses directed me not also consider my personal hearing also.
Yes. Why will hearing be given to you?
So that this was violated.
No. The authority knows where it has been violated, where it has been not. Acha, ki bolam? 28th of November 2023. Stop. I have heard the submissions made on behalf of the petitioner and have perused the grounds for review. Stop. None of the grounds mentioned in the application for review can be attracted in the instant case for which a review is called for. Stop. Next. In view of the above, the application for review stands dismissed. Had it been that type of case, I would have awarded cost. I am leaving it this time.
Section 5 But can you record that the section 5 is allowed, not delay is condemned?
There is an application for condoning the delay in filing the application for review. Stop. Peruse the same. The delay in filing the review application stands condoned. The application for delay is heard on merit and dismissed.
Similar order was passed. So similar order will be passed.
Same. Yes. Order date tao same 208. দুশোর সাথে সব ক্যান গুলো ডিসপোজ হয়ে গেছে, একটাই হয়তো বাকি আছে, আগের গুলো ডিসপোজ হয়ে গেছে, চেক করে নেবেন।
Madam, for the petition.
Petitioner?
Madam, for the petition.
What is it?
Well, there was a report called for.
From?
From BLLRO.
From?
BLLRO.
BLLRO.
My lord.
Who is appearing?
I beg to appear for the person who has been arraigned as a contemptor without making any allegation in the petition that you have violated the order of the court.
All right. BLLRO, who is appearing?
My lord, my lord, in this matter, I am appealing for the BLLRO.
Yes. Where is the report?
My lord.
My lord, I am advocate for the Pradhan submit that the records relied upon by the are incorrect. Their proper extract with plot number at the 678 plot number.
My lord,
recorded in the name of
will you lordship pleasure me to
collector? Yes, I'll see the record and see whether the portion which recorded is used as a pathway.
Me to take this point before my
specific instruction was to be taken by the state as to whether there is any encroachment by private party over any government plot of land. What is the... There is encroachment?
Yes, my lord.
Who has encroached?
My lord,
and the...
respondent number 6 and 7, my lord.
Respondent number 6 and 7 has encroached.
My lord, as per the field inquiry report, my lord, done by the revenue inspector, my lord, a portion of the 4th-story building is actually encroaching 0.03 acres, which stands in the name of the collector, Government of West Bengal, and 0.01 acre, which stand in the name of the patta holder, Nimai Chandra Parial, my lord.
Who are you? Which portion are you occupying? Any portion of the encroached land?
I will answer that later.
All right.
My first point is, my lord is hearing a contempt application.
Yes.
What is the decision of your lordship's order? Authority is directed to consider my representation and to dispose it of.
Right.
That has been not disposed of by the authorities, my land defense client. Your lordship passed an order to dispose it of. After the disposal of the order, in either way, whether, my lord, the contempt proceeding can be carried on thereafter. Had it been an order, it can be a fresh cause of action, so it can be challenged in accordance with law. And today, my lord, if at all, I find, my lord, what has been stated by my learned friend, that property encroached by my client, then, my lord, there is a specific statute by which they can initiate proceeding with a right to liberty to approach the authority to answer my question. In the contempt proceeding, whether, my lord, can go into this question or not, this is my precise.
Let the finding come on record that there is an encroachment.
They cannot find.
What do you mean to say they cannot find?
For finding that, they have to initiate a proceeding.
Yes.
No proceeding up till now.
All right.
Kindly see your lordship's order, original order.
I'll see my order later on. This inquiry was conducted. Did you give notice to all parties to appear?
My lord, from the last order, my lord, we were actually directed to take the proper instruction as to the exact portion of the land, my lord. My lord, by virtue of this report, I am actually placing the exact portion of the land, my lord.
No, I see. It appears that there is an inquiry conducted.
My lord, field inquiry report,
yes.
my lord.
What does field inquiry mean? Somebody went over there?
My lord, somebody went over there.
Right. So
the revenue
inspector went over there. Now, if the revenue inspector goes over there for measuring, then will you not give notice to them?
Whether
was the petitioner put on notice?
That was done.
Petitioner was
that was done.
Notice?
Earlier that was done. Notices were informed to everybody. The moment report was supposed to come, they preferred an appeal. Since appeal was pending, entire proceeding before your lordship in respect of contempt was stalled.
No,
now,
I
in
have seen the
appellate court,
appeal court's order.
Yes, my lord, appellate court order your lordship has seen.
Yes.
Now, this is what they are saying, that they were not invited. Everybody were invited, and in their presence, report was submitted.
And was any signature of the persons present taken?
My lord.
It was taken?
My lord.
Very well. Please circulate this report.
My lord.
Please come.
Well, I want to canvass that point, Madam. If you
Which can? What canvas?
Contempt proceedings cannot proceed.
Listen, those are all. The court is aware of it. The inquiry report. Nothing. The inquiry report.
Because the High Court Division Bench said you can take this point before the Honorable Single Judge.
Yes, yes. You are taking this point.
I am taking, my lord. Allow me to place it.
The inquiry report. Filed by the Assistant Director and Block Land and Land Reforms Officer, Khanakul -Roman to Hooghly, dated 8th July 2025. Placed in court today by the learned advocate representing the state respondents is taken on record. Stop. Copy of the same circulated. Copy of the same has been circulated to the learned advocates representing the respective parties. ঠিক আছে? It appears therefrom that as per the present computerized LR record of rights of LR plot number 678, Mauja Rajhati, jail number 82, out of the total area of 0.04 acres comma, an area of 0.03 acres have been recorded in the LR Khotian number 1 in the name of the collector, and the rest measuring 0.01 acre has been recorded in favor of the Pattadar Nimai Shankar Parial, son of Achyutananda. Vide LR Khotian number 5322. Stop. The report mentions that no portion of LR plot number 678 is used as pathway at present. The report also mentions that a portion of the 4-storied building which is under construction by the respondent numbers 6 and 7 Where is the respondent number 6 and 7? Respondent number 6 and 7, who are they? Yes. Respondent number 6 and 7. What is the name?
Biplab Ghoda and Pratima Ghoda.
Where?
6 and 7, we are appearing.
In Writ petition, they are
Contempt number 3.
2 and 3, the 6 and 7.
Respondent number 6.
In the Writ petition. My lord is hearing contempt application.
6 and 7 in the Writ petition. Ki naam?
My lord is now hearing the contempt application, where I have been arraigned as contempt number 3, 2 and 3, without any allegation against me in the contempt petition.
Six and 7, Biplab Ghora, Pratima Ghora.
Ghoda na ghodai?
Ghorai? Ghora?
Ghoda.
Ghoda.
Not ghoda.
Sritin Ghora. Acha. Has encroached almost the land measuring 0.03 acres of plot number 678, which is presently recorded in LR Khotian number 1. Stop. Paragraph. A portion of the said 4-storied building shall say portion of the said 4-storied building is almost includes the land measuring 0.1 acre. It's the same thing. Acha. A portion of the said 4-storied building which is under construction by the aforesaid respondents has also encroached the land measuring 0.01 acre of plot number 678. In LR Khotian number 5322, which is standing in the name of Nimai Shankar Parial. The photocopy of the LR information plot number 678 has been annexed with the report. Stop. Paragraph. The court disposed of the writ petition by directing the Panchayat to arrive at a decision as to whether the land in question is a public pathway and as to whether the construction that has been made thereon is in accordance with the sanction granted by the Gram Panchayat. Who is the Panchayat?
The Panchayat. He's the Aspen Panchayat, Milord, who gave the permission. Now I am the present contempt.
Has any sanction been issued?
Yes.
Petition issued, Milord. Patta was issued after the disposal of the petition 2022. See the Khotiyan.
We claim.
Petition of Khotiyan, Milord.
Yes.
After selling the property, I am the Panchayat. After selling the property, Padial estate to the respondent numbers 7 and 8, that is private respondent number, contempt number 2 and 3, that Patta has been issued in favor of the Nimai Padial creation date. Many things has to be decided. That's why the contempt is not proper jurisdiction.
Of appeal, my lord.
1 minute. Let me understand. Yes, thereafter.
Hereafter I am telling you that 683 land, RS land was 8 decimal. That devolved into, according to the BLRO reports, it devolved into 678 and 679.
You say sanction has been granted.
Sanction has been granted, Milord, basis from the mutation from the BLRO department. I have no role on that. I have not opened my mouth on merits because according to me, my lord, this cannot be decided in the contempt proceeding.
The learned advocate representing the Pradhan asserts that construction has been made in terms of the sanction issued by the Panchayat.
Panchayat basis on the mutation.
Stop.
By the BLRO.
The learned advocate for the petitioner submits that sanction could not have been issued.
Could not have been issued from the very beginning at the starting of construction.
Very well, could not have been issued. Stop. The aforesaid issues cannot be decided in the contempt jurisdiction. Stop. It will be open for the parties to agitate all issues before the competent forum in accordance with law, if so advised. Contempt application stands disposed of.
Great.
211, I am for the petitioner led by Mr. Moyuk Mukherjee. My lord, he is in Jalpaiguri before the circuit bench. My lord, praying for not today, my lord.
This is absolutely not a ground for seeking adjournment.
My lord, he is.
There is a matter pending here.
My lord,
Somebody else can always appear. Why will adjournment be granted? It is your review.
yes, my lord.
Then where is the advocate on record?
My lord, I am there.
Then you should be prepared. And when was it filed?
Probably there.
August 24. 1 year has passed. Who are you representing?
I am representing respondent number 5, my
Respondent
Respondent.
number 5,
Once-
private respondent.
private respondent, my lord.
All right. What was the order?
Grievance pertaining to this this guideline regarding the Arnesh Kumar judgment, my lord. This is the crux of the.
My lord,
Yes, please.
if my lord says kindly sees the order
Yes.
which my lord has passed, my lord kindly sees the last page, that is page 19, my lord.
Yes.
My lord, the petitioner prays for compounding of offences. My lord, but the prayer was for quashing of the offences. Compounding cannot be done by me because I am the accused, I am not the complainant.
Right.
So this observation, my lord, is hampering the petitioner before the learned court below. My lord, Mr. Moyuk Mukherjee want to argue or submit extensively upon this thing.
Why extensively? Is this the only thing that is troubling you in the order?
No, my lord, there are a lot, because now this matter is not at the stage that we can approach the learned court below for discharge or some appropriate steps.
Is
My lord,
trial
we want-
continuing?
Yes, my lord.
Then what remains in the review?
My lord, we want quashing of this offense. My lord, quashing of the entirely PS case. Due to this observation, my lord, we are suffering before the learned court below, and thus, my lord, we came here for the review, and my lord, now we want to
I see the councils have changed. Now with the change of councils, the character of the case has also changed.
my lord,
Submissions have also
my lord,
changed.
the prayer is for quashing of the quashing. My lord, if kindly, my lord, sees the prayer in the writ petition, my lord, it's for quashing. The prayer is for quashing. And my lord, I cannot pray for compounding, because compounding can only be done by the complainant. And I am not the complainant in this case.
Charge sheet has already been
That
filed.
has been filed.
Right. She was compelled to file the complaint. See, the compounding portion can be taken care of, but then if the charge sheet has already been filed, and what is the position of the trial?
Trial, my lord, it has means to as per my instruction, it just means the charge is about to be framed, my lord. As per my instruction, my lord.
About to be framed.
Right. Charge of frame হবে.
My lord, kindly gives us an adjournment so that, my lord, Mr. Moyuk Mukherjee can satisfy on
The compounding part, it's a technical thing that can
That can be taken care of. That I can understand. But then otherwise, last occasion also.
My lord, I have no other option left to approach the learned court for the appropriate steps. My lord,
appropriate steps means you proceed with the trial.
My lord, this is my lord, it's a civil dispute which was going on before the learned court below, my lord. Where, my lord, without following the
accommodation has been sought for on behalf of the learned counsel representing the petitioner. Step. Released for further consideration on 14th of August.
Much obliged, my lord.
My lord, on that day, my lord, I found it. Even except 14th, any day, my lord.
My lord, if my lord kindly keeps it in the next week, my lord.
7th, 21st, my lord, in the country.
7th of August.
Ram for the petitioner.
Yes,
For this is my affidavit of service.
yes.
Order under contempt is at page, my lord, 38 of my lord's brief. That kindly takes up page 40, the operating portion. It has two parts. Since the PHE department, my lord, Public Health Engineering Directorate are going to are now constructing a project for the purpose of construction of supply Shakrail water supply scheme. My land is being included. The coordinate bench of your lordship course, by disposing of this writ petition, directed first the PHE, the directorate, to first inquire whether my land, as mentioned, is within the project area or not. If that be so, thereafter that to be done within 45 days, and thereafter, if it is within that, then proper acquisition proceeding to be done as per the right to fair compensation and transparency in Land Acquisition Rehabilitation Act.
Your Lordship, Mr. Jayanta Samanta appears for the alleged contemners. Your Lordship, in this matter, an appeal has been preferred along with an application for stay, and both the appeal and the stay are pending adjudication, Your Lordship.
But this is a time-barred appeal. My lord, kindly consider a simpliciter direction for identification that whether page 40 kindly looks at.
1 minute. 4th August 23 is the order.
My lord, 4th August 2023 is, my lord.
And today we are approaching August 2025, and you will say that the appeal is pending and not comply the court's order.
And that has been filed, my lord, in the summer vacation.
I am not inclined to buy your submission. Right? I am adjourning it, file affidavit of compliance. The learned advocate representing the contemptor submits that due to the pendency of an appeal against the order from whom the contempt application, from which the contempt application has been preferred, is pending consideration, the order of the court has not been complied with. Stop paragraph. The court does not appreciate the stand taken by the contemptor. Stop. Judgment was passed by the bench on 4th August 23.
And blood appeal affirmed in the year 2025.
And till date, the same has not been complied with. Stop. There is no order placed before this court, either setting aside / modifying or staying operation of the judgment which the petitioner seeks execution of. Stop. Next. In view of the above, the order passed by the court is required to be complied with. Stop. Hearing of the contempt application stands adjourned till 14th August 2025. Stop. An affidavit of compliance shall be prepared and circulated prior to the adjourned date.
Great. The affidavit of service be kept.
Yes, service is taken on record.
Great.
Passover ache? Very well, call. Other regular matters will not be taken up. Passover.
9, 17, 19 to 22. The lordship kindly recommended me for next week. I will not be available. My personal deal. 17, 19 to 19 to 22.
Yes. What is going to happen? Let somebody mention it. I'll let
my item 4. My item affidavit of compliance.
Yes.
Ready, but I have my
Keep somebody with the compliance report.
But item 494, my lord, I had mentioned last week, my lord, with regard to for providing.
Your other side there.
He was here, my lord. I'm just.
Yes.
My lord, item 218. The order has been complied with. My other side is here.
218.
218.
अच्छा, order लिखे नहीं तो. 218. Learned advocate representing the petitioner submits upon instruction that the order passed by the court has been complied with. Stop. Next, in view of such submission, there is no requirement of proceeding with the contempt application any further. Stop. The same stands disposed of. Appearances, please. Yes.
I'm from the alleged contempt number 2.
Petitioner কোথায়? Where is the petitioner?
I tendering my apology, my lord, for not being there when the matter was called on.
Matter has not been taken up.
No,
Is this the
I'm
Passover
tendering my-
matter?
No, it was not
Yes,
there,
my
my
lord.
lord.
Oh, this is the Passover matter.
Yes, my lord.
Yes.
Pursuant to lordship's direction,
Yes.
on last occasion, the instruction, my lord, what I have received, I have put on by your affidavit. Your lordship, that I have filed, my lord, and last occasion, your lordship was pleased to direct that to my lord, tag with lordship's record, my lord. I do not know, my lord, whether the affidavit in your lordship's record.
Did you get the opposition?
Yes, we have
My lord, that,
from the reply
my lord,
also to
All right.
the opposition
That
filed by
the
you.
last occasion, my lord, my lord, before I'm placing the affidavit, my lord, may I take your lordship to a lordship's order for once? That is a two-part, my lord.
All right. এই জানাবো অপোজিশনটা এসছে ওইদিকে তাকাচ্ছেন কেন? জানবেন তো আপনি, অঙ্ক জিজ্ঞাসা করছেন।
Next.
একদম কোনো বাদ নেই, আমি আজকে গিয়ে
Let it remain in its position.
yes, same position.
My item 494, my lord. My learned friend is here, my lord.
494
Yes.
20, my lord.
আর সিরিয়ালি ডাকবেন তো।
420. My lord, it's my affidavit of service and my lord, the notice, my lord.
494
494.
other side.
My,
Yes.
my lord was pleased to direct the station manager to provide electricity for energizing the submersible pump, my lord.
Has it been done?
No, my lord. Till
Why?
I tell you, lordship. But first of all, I at the outset said there is no contemptuous act.
All right.
The petitioner, there is a specific direction for granting the electricity. Now, on that basis, we have made all endeavor to grant the connection. And lordship knows it's a field, paddy field. So we have to draw the line from the other end, from the other fields also. And we have got the serious objection from that. In spite of that, we have given notice to them. We have made a joint inspection. We have told them to show the alternative way. But till date, no alternative way has been shown. And your lordship knows, as per regulation 46, clause 3.2.1 C, where it has been, I am showing to your lordship, where it has been specified that wayleave permission is necessary for granting electricity. But we are not getting any wayleave, but they are giving the serious resistance. But in spite of that, we have filed an application before the concerned district magistrate. And this is still pending. Now,
It's still pending.
yes.
Are you aware of all this?
Now we are.
The client has not
Now we have
indicated you.
given the letter. They have refused. Series.
You file an affidavit disclosing all facts.
Lordship.
Acha. Learned advocate.
Now we have made a
representing the
meeting. Everything.
Contemptor annex all those.
Yes.
Submits that steps were taken to comply the order passed by the court, but due to severe objection raised by the persons over whose land the electricity connection will be laid, LAID. The electricity connection to the petitioner's submersible pump could not be given. Stop. Despite request, the petitioner was unable to obtain a way leave. Stop. Prayer has been made before the district magistrate, which is pending consideration for an alternate route through which the electric wire can be taken. Stop. Paragraph. Learn the
One thing
contemptor-
subject to law. But so far, district magistrate cannot grant the alternative way for compensation. Your lordship knows that on that basis.
Before for compensation, wailing now lasted
Wailing
DM এর কাছে
permission
আছে
is
for
granted by DM.
compensation. না শেষে বললাম না পেন্ডিং বিফোর দ্য ডিস্ট্রিক্ট ম্যাজিস্ট্রেট কিসের জন্য? না ফর কম্পেনসেশন। ঠিক আছে। Release the matter on 14th of August 2025.
14th month. Can it be after that? But next week.
Today we are in July 10th. 14th August.
14th August, I have two fixed matters subject to appeal matter.
21st.
I'm sorry, lordship.
21st August.
I'm deeply.
21 তারিখ
Lordship, kindly don't take me amiss on that.
21 আগস্ট কি বলে copy of the affidavit shall be circulated in advance to the learned advocate representing the petition.
But during this harvest season,
Harvest আর একটা কি নোটিশ আছে
but during this harvest season, I'm suffering some precedents. Instead of
Daily permission.
even if I prepone, you will not get any benefit because it is pending before the DM.
And the wailing permission is
I have to
necessary.
take the way.
Lordship knows that.
Next.
This is my application.
The innerটা বার করেছেন ফাইল
I'm filing.
71. I'll take it up.
I'm for the one that contempt respondent.
Contempt respondent. Yes, which authority?
Against the order passed by your lordship.
Raghunathpur municipality.
Lordship. Against the order passed by your lordship, appeal was preferred, appeal has been dismissed. My lord, kindly, my lord, allow me to come. There is a administrative chaos in the said municipality, my lord. The board was superseded by the government, and my lord, after my lord, pursuant to the order of this honorable court, my lord, the chairman took charges only 4th July, my lord, only on 4th July. My lord, so my lord, some time is required for, and my lord, furthermore, my lord, so far as my lord, monthly pension is concerned, my lord, petitioner has not submitted his life certificate on the relevant point of time. My lord, kindly allow me. But my lord, after submission of the documents regarding life certificate, my lord, pension has been releasing month by month. And so far as my gratuity is concerned, not only the petitioner by my lord, there are other several retired employees, more than 20, my lord. They are also not getting the gratuity due to my lord crunch of the fund of the municipality. Municipality is not in a position to pay the my lord gratuity at this stage, my lord. They are trying to, my lord, they have already wrote some letter to the my lord, higher authorities for granting some grants, my lord. My lord, the appeal was preferred only for a direction upon the my lord, state authority to provide some grant so that my lord, the gratuity can be allotted to the my lord, other employees related, along with the my lord, petitioner also. And my lord, and for granting some time, my lord, so that my lord, order of my lords can be complied with. That is the my lord, prayer of the my lord, appeal before the appeal court also.
When did the person retire?
He retired on 28th of February 2023.
February 23.
So far as gratuity is concerned, petitioner,
What portion you are not receiving? Gratuity?
Gratuity I have not received any amount, and so far as my pension is concerned, I'm not getting according to my entitlement.
Not getting according to
According to
entitlement.
my entitlement.
All
I'm
right.
getting some, but I'm the authorities has issued letter to the petitioner, my lord, asking him to remain present before the authority, so that the letter, even my lord, 3rd July also a letter was issued to the petitioner. Petitioner has my lord contacted.
Go to the residence of the petitioner and see whether he is alive or not. All right.
So far,
Life certificate you want?
not for last.
Go to the petitioner's house and see whether he is alive or not first. And second, 3 years, the interest rate is more and it will multiply. No kindness. You have extracted his service and you will not pay pension and gratuity.
Pension is
Sorry, sir.
pension
This court is not
so
with you.
gratuity is concerned, my lord,
Please
that
come.
has to, my lord,
The order of the court
my lord, there is a
has not been
chaos also, my
complied
lord,
with till
I
date.
consider.
Your chaos will not stand in the way of the petitioner receiving his gratuity.
4th July, my lord, the chairman took my lord for the charge, my lord.
Yes.
That may record my submission, my lord.
The not been complied with. It appears that the order passed by this bench stood affirmed by the Honorable Division Bench. Vide order dated 8th April 2025. In MAT 1593 of 2024 with IA Can 1 of 24, Can 2 of 24. Raghunathpur Municipality and another versus Ponchanan Singh and others. ঠিক আছে? The petitioner retired from service of the municipality in February 2023. And even though PPO was issued in his favor in May 23, but the gratuity amount and the pension amount as reflected in the PPO is not been disbursed in his favor.
My lord, the pension amount is paying, my lord, my lord. According to me, ROPA is not granted, my lord.
The petitioner is not getting the benefit under ROPA.
According to the petitioner, but
Next. Learned advocate representing the municipality submits upon instruction that because of the internal chaos of the municipality, the order of the court could not be complied with. Stop. There is shortage of funds. Stop. The new chairman has joined the post in June.
4th July, my lord.
Achha,
No,
4th
he was
July
there earlier, but
2025.
not
Stop.
new chairman.
Paragraph.
Erstwhile chairman is also, my lord, took further charge, my lord.
Acha. It appears from the order passed by the Honorable Division Bench that the shortage of funds for not releasing terminal benefits has not been taken to be a valid ground for not dispersing the terminal dues of a retired employee. Stop. The municipality submits that the petitioner has not deposited his life certificate. Stop. Paragraph. It will be open for the representative of the municipality to visit the petitioner and ascertain as to whether he is still alive or not. Next. The petitioner was to receive the dues with 6% interest. Had the same been paid within the stipulated time period, failing which 2% additional interest was directed to be paid. Stop. As the municipality failed to disburse the terminal dues of the petitioner in compliance of the court's order, accordingly, the petitioner would be entitled to receive his dues with interest at the rate of 8% per annum. Stop. Hearing of the contempt application stands adjourned till 28th August 2025. Stop. In the event the entire gratuity amount and the other arrears of the petitioner is not paid by the said date, the chairman of the municipality shall remain personally present in court. Affidavit of service taken on record.
My lord, please, your lordship, I am for the petition.
Yes.
My lord, kindly see the order passed by your lordship on 4th of December 2023.
Yes.
My lord, kindly see the petitioner complained of illegal and unauthorized construction at the behest of the private respondent 4. Learned senior counsel representing the respondent for submit before the court that no unauthorized construction has been made undertaken.
Yes. 1 minute.
So
immediately I have contacted the concerned bureau. Malad Paras, the petitioner is in wrong conception, Malad. Malad, though the physical report is not with me, so far the premises number 5A is concerned. Malad, the plan has been, Malad, it has been regularized in pursuant to the Malad MIC meeting on Malad 5/5/2025. And so far the 5B is concerned, Malad, a plan has been sanctioned.
You file an affidavit disclosing all documents.
in the meantime, what I am praying, my lord, stay not to construct in the said premises, my lord.
Sanction plan.
But my lord, kindly see the last portion of the order. That is paragraph.
Learned advocate representing the contemners submits upon instruction that order of the court has been complied with.
No, my lord.
Let affidavit of compliance be prepared
No.
and circulated by 18th July. It is ready with you.
No, soft copy is
Soft copy is there. Today
Madam-
is 10th July. 18th July, he
Next
prepared the
week, your
affidavit.
lordship kindly accommodate me on the next week.
Next
Next week
week.
I will not be here on my personal difficulty.
Entire week you will not be there?
I'll be out of town.
আচ্ছা তাহলে ওটাকে করুন
Malad constructed
ওটা হচ্ছে
in the manner whatsoever is not
23rd.
carried out. In spite of that, they are carrying out, my lord.
Released on 31st July.
Malad, in the meantime, Malad, what I am paying stay of the construction, Malad, is totally instruction.
Corporation says it has been regularized. So you have to challenge that. It is only for this purpose the matter is made returnable. 498. 498. কি আছে 498? Was it mentioned? আপনার মামলা?
হ্যাঁ ম্যাডাম
হ্যাঁ কে আছে?
Of May 2025. My learned junior was unwell and she could not attend your lordship.
Restoration?
Restoration.
Who is your
Lordship, I am appearing for the respondent.
Unappeared of
respondent number?
bank.
Bank.
State Bank of India?
Yes, Lordship.
My grievance against the bank. Urgency is copped up certainly.
Lordship, kindly fix the matter. Lordship.
Restoration I'll allow. আচ্ছা restoration টা allow করে দিন ঠিক আছে What is the grievance?
Grievance is petitioner took loan.
Hmm.
First owner is wife. Second owner is petitioner. But now in the meantime retired. But 32,000 pension. Loan amount 26,370. Deducting from the pensionary benefit. Now he is the patient of spinal cord operation. Needs money. He is not able to continue.
Listen, when you have taken a loan, you are required to pay.
My prayer is that let them take the possession of the bank under the Surface Act, let them sell out. If I get any money from 2021 to 25, I have paid all these EMI.
How much is due now? How much is due?
Due 25 lakhs loan, 21 to 25. And
the petitioner
already paid.
The learned advocate for the petitioner submits that the petitioner is not in a financial condition to pay off the loan amount. Stop. He is a retired employee and the monthly installments are deducted from his pension account. Stop. He requires the money for his medical treatment. Stop. The petitioner submits that the bank may take steps to sell off the secured asset in accordance with the provisions of the Surface Act and return the balance amount to the petitioner. Stop. Learned advocate representing the bank shall take necessary instruction. Stop. The bank shall furnish before this court the amount taken by the petitioner on loan, the amount repaid by him, and the amount that is due and payable. Followed.
I'm seeking, yes, your lordship kindly to add my wife as my party respondent because that joint owner in that, unless she gives no objection, they can take that plea.
Your wife is with you. You'll have
yes. 4,000 alimony expertly directed by the competent court of DV court to pay. Then 26 plus 4,000, 30. I am getting 32. That is the whole problem. And 498 case.
Where is your wife staying now?
In that particular.
Yes. So you want that
and
property to be sold off.
I am staying. Let their leave be granted.
Now I have
I know. Your lordship is there to solve the problem. I told my learned junior, it is there. My lord, this is not the anyway settled principle of law. Your lordship is there anyhow. Anyhow.
Leave is granted to the advocate on record of the petitioner to implead his wife as party respondent in the instant writ petition and serve copy of the writ petition upon the added respondent.
Much obliged. I'm just telling Mr. Chattopadhyay.
List.
Any date.
28th of July.
Grateful. I tendered apology for my junior on that date when she could not appear. Grateful to you. Much obliged.
23 Millard, I am for the petitioner Millard.
And for the Union of India,
Millard. Restoration application Millard. On that day Millard, my junior was, I was not present, my junior was engaged in court number 34 and after court number 34, he asked to this court Millard. In the meantime, Millard, application dismissed.
And what is the relief sought for in the writ petition?
Millard, writ petition Millard. Employees Association of the petitioner was recognized by the authority. Employees Association of the petitioner was recognized by the government of India Millard in the year 2002.
Yes.
Thereafter Millard 2019 association was de-recognized with the liberty to file afresh and 2000 following rules 5 CCA and following.
What is your prayer in the writ?
Petitioner applied for recognition. That application is still pending since 2020.
Which page?
Millard, page 19. Page 19.
Page 19. Who is the other side?
Millard, I am for the Union of India.
Page 20, department also recommended for recognition of the.
Page 19 is by the President of Non-Gazetted Employees Association. Petitioner is
Is the secretary of the association, proposed association.
Other side কোথায়?
secretary of the newly constituted association.
কত নম্বর item?
What will be your prayer with regard to consideration of page 19?
Page 19, my lord, they are asking for the recognition, my lord, of non-gazetted, my lord. To that effect, my lord, page number 18, my lord, they have already filed an application before the general manager Farakka Bridge project, my lord. They are referring that and they are asking for that recognition as per the CCS RA rules, my lord. Therefore, asking.
Why don't you take a decision and
My lord,
come
kindly
in?
direct.
Can be done?
As
Restore
per
করে দিন।
provisions, they will do.
The petitioners pray for consideration of the representation seeking recognition of their association in accordance with law. Stop paragraph. As it appears that the prayer of the petitioners is pending consideration before the authority, comma, accordingly, the instant writ petition is disposed of by directing the
Respondent number 2, my lord, 2 or 3.
2 and 3, my lord. Anyone. Secretary and under secretary, my lord. Respond number 2 and 3.
2 and 3.
2 and 3. They are also referred to their prayer, my lord.
No, they may have referred, but this one will take a decision, and page 18 is addressed to the general manager.
Respondent number 2.
Then you lord. Secretary, they have referred secretary, my lord.
As a respondent number 2.
If you lord only one indulgence or any competent authority, then he finished.
I was thinking of the respondent number 5, the general manager of
No,
the.
my lord.
No, my lord.
General manager
Cannot-
forwarded.
He is the forwarding
The
authority.
authority is the 2 and 3 is the authority. My lord, 2 or any competent authority.
My application before the
Respondent number 2 or any competent authority
lords.
to take a decision on the prayer of the petitioner in accordance with law. At the earliest, but positively within a period of 8 weeks from the date of communication of this order, a reasoned order shall be passed and communicated to the petitioners immediately thereafter. Stop. Learned advocate for the petitioners is directed to forward a copy of the representation seeking consideration along with all supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed.
My lord,
Can and WPA.
I am filing affidavit of service.
Yes.
এটাকে allow হয়ে
To
যাবে।
item number 466, my lord, restoration application, other side is present, my lord. I mean.
You did not mention in the morning.
Sorry, my lord, I am
Then?
my lord, I am taking chance before lordship, if you lordship kindly
Taking
allow.
chance.
Kindly, other side is one present, only
Who
restoration.
is your other side?
Lordship read by Mr. Galip, I am for the state risk handling.
Yes, what? Restoration.
Restoration, only my lord.
Order date?
My lord.
Order date? Order a date.
Oh, my lord, yes.
কত item?
Order dated, my lord, 25th February 2025.
February 25? না, এখন করবেন না।
Time, my lord.
Maybe within time. You are mentioning it today.
I have tried to mention, my lord, twice. My junior tried to mention.
Tried to mention means?
Monday, my lord, he tried, my lord.
Monday? No, sir. This is an absolutely wrong impression. Applications, if they are in the list, you bring your other side, I allow.
My lord, very kind enough.
I allow it. No issues, but it was of February. The matter which I restored is immediately last month or preceding a few weeks.
That is running, my lord.
That is the reason. Come on the next day.
Urgency.
এই পরের দিন এটাকে উপর দিকে দিয়ে দেবেন। Urgency? Next day?
First time.
Stop.
I'm ready.
466?
466.
466 পরের দিনকে আপগ্রেড।
Lordship.
No order.
Okay.
Yes, first time call.
Hey, next week, this night. I
25 minutes, I appear for the petition. Let the name.
Name of the new incumbent is to be inserted.
All right. $23 matter. The order is of 22. Why are you presenting it for after such a long period of time?
That we have tried to mention, but we could not.
কি ঠিক আছে দিয়ে দিন leave to add the new incumbent executive engineer civil building
Yes.
ঠিক আছে এটা returnable হবে 7th of August. Serve.
Lordship, subject to leave, Lordship, item number 513, it is a contempt matter, Lordship, order has been complied with, Lordship, kindly update it, otherwise not taken.
Who are you?
I am for the alleged contempt, Lordship.
Where is the other side?
I informed the other side, Lordship, kindly update.
No, I do not know.
Otherwise,
You had the petitioner come, I would have disposed it of here and now. Bring your other side.
Lordship, kindly update it, otherwise.
No, no. You know, you are the contemptor. You must be knowing who the petitioner is.
I know, Lordship.
Then bring him.
Lordship.
কি আছে? None appears for the petitioner at the time of call.
527 Millard, the name of the new incumbent is to be inserted.
Yes, দেখি। Same person, Dibyendu Pal. এটাও চেঞ্জ হবে। হ্যাঁ, এক্সিকিউটিভ ইঞ্জিনিয়ার সিভিল বিল্ডিং চেঞ্জ হবে। ঠিক আছে? Same date returnable.
I'm preparing for the petition now.
Yes. What is your submission?
But I filed sub the notice of your order by order has not been complied yet.
You have served already?
No, not this, your Honor's order.
Communicated the order.
I have communicated your order, Your Honor, but no, it's
Not complied. Yes. Serve notice.
Okay.
7th of August, it is made returnable.
Okay.
Millard, your Lordship's order operative portion is at page 18. We have communicated on 27th of January 2024 at page 19.
Not complied. Yes, yes. Serve. No, new incumbent name.
No, first time. Order
Serve.
10th of October 2020.
Very well, serve.
Date returnable?
7th of August. Petitioner? Last time? All right. Yes.
My lord, with regard to 500, my lord, as per your lordship direction, the copy has been stopped. My lord, your lordship is directed to demolish the illegal structure, and therefore, thereafter, my lord, they have preferred the appeal. Appeal was dismissed, and my lord, still they have not, my lord, comply your lordship's order.
Yes. Why are you not going before the division bench? Appeal was dismissed by the division bench.
Yes, my lord.
Yes.
Appeal dismissed.
Right.
And therefore, my lord, I am mentioning before your lordships. It is not complied with till now.
Who is your other side?
My lord, other side, I don't know, but Anirban today, my lord, I have taken information, Rajorshi Basu and Anirban Datto.
They are not for. They are not for the Pradhan of the Gram Panchayat.
No, my
they must be for the state respondents.
I do not know who is appearing on behalf of the Pradhan.
Very well. If 500 টাকা তুলে দেবেন উপর দিকে।
My lord, rule is issued, my lord. The order will not be complied with.
517, my lord, an application for restoration, my lord.
When was it dismissed?
And that was dismissed on 5th of previous month, my lord.
Who is your other side?
My lord, I had called upon, but
nobody is here.